Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you, Madam Clerk. I want to welcome everyone to the courtroom of the United States Court of Appeals for the Fourth Circuit this morning. We have 4 interesting cases, and we look forward to the arguments of counsel to help us resolve them. In the first case, number 25-1412, Blowsurf versus T-Mobile. Mr. Peterson?
Yes, sir.
You represent, maybe it's Blowsurf. You can tell me how to pronounce it. But it's, we're pleased to have you with us, and the floor is yours.
Thank you, Your Honors. May it please the court, Chap Peterson for Blowsurf LLC. We are the appellant. This case comes before you from a 12B6 dismissal of our complaint from the District Court of Maryland. My client is a rural broadband provider, primarily focused on the Eastern Shore of Maryland, although he also does business in Delaware and Virginia. He has been in business for over a decade, has contracts on the educational broadband spectrum, which he leases in order to provide his rural broadband service. Cause of action first arose in 2021, early 2021, when we began experiencing interference with our signal. Somebody had been transmitting across our spectrum where my client, again, had leased it through the EBS program. We spent years investigating. I could go into granular detail, which is in our complaint, but I found out that it was emanating from towers that were owned and controlled by T-Mobile. And we ended up, as again, spent years investigating, made an initial investigation inquiry with the FCC. We're not able to solve the problem. The interference continued over a period of years, and we finally ended up filing a cause of action in April of 2024. We then amended that cause of action in November to add an additional count, which had to do with T-Mobile through a subsidiary, which had effectively taken away our contract for the EBS spectrum that we held with 3 universities in Maryland that were located on the Eastern Shore. That was the case that was before the court, that was then dismissed on a 12B6 motion, and that is the appeal that occurs before you today. The first legal issue that's before this panel is really a very basic one. We had filed a suit. Our count 1 was under the Federal Communications Act, as originally enacted in 1934, then reenacted in 1996. And we brought a private cause of action under that Communications Act under Section 207. And the question is whether or not Section 207, whether or not the Federal Communication Act, as reenacted in 1996, allows a direct cause of action. And our position is it does, and in doing so, we rely on the plain language of the statute. And I'll just quote from it, which says...
So let's assume that... Go ahead, Judge AJ.
Well, even if we assume there's a private right of action under the Section 333, I think it is, there's an election of remedies provision in 207.
Yes, sir.
And tell us why that wouldn't foreclose your claim under count 1.
Well, it wouldn't, because we haven't sued for damages to the FCC. We really haven't.
So why does that make a difference? Because the statute says you can either make a complaint to the commission or bring suit for the recovery of damages, and it doesn't seem to limit the complaint's gravamen to damages or equity. And I mean, there are a number of cases that, at least that I've read, that seem to say, you know, it's one or the other, regardless.
All right. Well, I think, Your Honor, I'd like to walk backwards, and before I get to 207, I'll get to 206, which says...
Don't you already have an appeal pending with the FCC on all this?
Well, we don't. What we have is there was a bid, an auction for what was called Section 108. That was one of the licenses that was awarded to T-Mobile. And we protested that award of the license to T-Mobile. That was the FCC action that's still pending. And in that protest, yes, we did mention this interference issue. There's no doubt about it. We raised it. We asked that T-Mobile not be given that auction. It would be the equivalent of if my neighbor trespasses on my property and I go to the zoning commission and argue against their rezoning, but then I also file a separate suit for trespass. They're not preclusive. In other words, we can still participate before the FCC on somebody else's petition or their attempt to gain a license and not forfeit any rights to bring a suit for damages.
So let me just bracket the question Judge Agee asked you, which is whether it matters if you sought damages from the FCC. But I'm looking at page 7 of your reply brief, which quotes what you asked the FCC to do. You asked them to take all actions to resolve the interference, including the payment of costs, including Blue Surf's cost to upgrade its network to eliminate the interference. So even assuming for the sake of argument that it would matter whether you asked the FCC for damages, why isn't that asking the FCC for damages?
Well, payment of cost to upgrade our network is very different from damages, Judge Heitens. I would say damages is...
Wait, so not only does it not matter whether you ask the FCC for money, but it matters now what specific money you ask the FCC. I don't know where any of that is in the statute. I mean, I'll say I tend to agree with Judge Agee that the statute doesn't seem to make it relevant whether you ask the FCC for money, but now it appears that you did ask the FCC for at least some money.
Well, Your Honor, we asked for costs to upgrade our network. That would be enabled to remedy the interference. That would not be the damages to our business.
Right, well, ordinarily, when we think of costs, counsel, ordinarily, when we think of costs, and they're reimbursable under a statute, we're looking at filing fees, witness fees, discovery costs, and that sort of thing. As Judge Heitens indicated, this seems to kind of bleed over into some type of what we would ordinarily consider to be monetary damages.
Well, Your Honor, I would put this in two different buckets. We have one bucket where we're trying to maintain a service to our, I use the word constituents, maintain a service to our customers. And in order to do that, we literally have to get off the network that we were currently using, or the technology we're currently using, and upgrade in order to continue maintaining the service to our customers. That's a cost.
Well, no, that's damages. Like, you're claiming that, just like think about this in the classic level of nuisance. You're claiming that your neighbor is doing something that is interfering with your enjoyment of your property, and one of the remedies that you're asking is for you to take steps to ameliorate the harm that the neighbor's conduct is causing you. That would be classic money damages. That's not reimbursing you for your filing fee or printing the JA. That would be a form of compensatory damages.
Well, Your Honor, I would say it's a remediation, it's a prospective cost. The damages is the customers that you lost. In other words, we lost half of our customer base as a result of this interference. There's no other reason that these people would have stopped using our service. And we never asked the FCC to compensate us for that. We couldn't. That's not something that they do. This interference, which happened over a period of years, literally destroyed our business. We've asked the FCC to intervene. We've asked them to take steps to allow us to, because we have to adjust our network technically in order to deal with this interference, in order to maintain our own what's called CAF standards. But the bottom line is by
You've fought it really hard. I'll say that for you. You sued in the state court too, didn't you? I mean,
we sued in, yes, Judge King, we sued in state court to try and, I'm sorry,
You're doing a good job.
Thank you, sir. Sir, we sued in state court to try and maintain our contract with the universities, because while all this was going on, we were literally being hit on two fronts. We were having this interference with our spectrum, which was costing us customers, and while all that was going on, the universities were trying to terminate our contract to lease the EBS spectrum. And so we had litigation with the universities. We tried to work it out. Then we had litigation to try and prevent the termination. We eventually filed a suit in Wacomico County. We did receive an injunction in August which required the universities to extend our lease with the FCC. That was subsequently vacated for 2 of the 3 universities, not the community college. So that's sort of been an ongoing saga in and of itself. But I want to, that's really apples and oranges to the interference issue. The interference issue is different. The interference is what happened to our business that basically crushed our business. I don't know how else to put it. It was repeated interference. It was not stopped. Yes, we did protest the Auction 108, the awarding of an additional FCC license to T-Mobile in that exact same territory, because we don't feel that they deserved it. But by intervening in that process, we don't believe that we somehow took away or divested the federal court of jurisdiction to hear a suit for damages on the interference issue.
Can I turn you to count 2?
Yes, sir.
So the question I have here is, I understand and believe that you and I have both practiced in Virginia State Court. So the question I have is, how is what you're trying to do on count 2 not the definition of approbate and reprobate? You asked the district court to apply a legal standard. The district court applied that legal standard, concluded that you lost under that legal standard, and now you're asking us to reverse the district court on the theory that it applied the wrong legal standard. That seems, in the Virginia Supreme Court, I think that would be a textbook approbate and reprobate type situation.
Well, Judge, I don't know as much as Virginia as you do, but I would say the following. I actually went back and reread our amended complaint, which raised count 2, and it states the standard for what's a tortious interference claim for existing contractual relations in Maryland, which is knowledge on behalf of the interferor, an existing contract, knowledge on behalf of the interferor, intentional actions pursuant to that, and then resulting damage. There was no allegation of an unlawful act or some type of improper method. And, you know, there were multiple tortious...
Sure, but when they moved to dismiss that count, what legal standard did your client urge the district court to apply in ruling on that motion?
Well, Your Honor, what I was going to say is I believe there was at least 3 different tortious interference counts. And whether or not they were mixed and matched in the briefs, the bottom line is yes, the earlier the earlier tortious interference counts all had to do with contracts that were terminable at will, and we did allege improper methods. And if that had been briefed before we filed count 2, then sure, it was what it was. But count 2 was qualitatively different in that was an existing contract for the EBS lease spectrum. So once count 2 was brought into play, those briefs had already been filed. Okay, we couldn't go back and fix those briefs, and we didn't need to fix those briefs. But count 2 was an existing contract, and so in our amended complaint, we actually laid out the standard. We didn't file a new set of briefs at that point. I mean, we talked about the amendment, but the bottom line is that issue was, you know, again, the court just simply quoted the wrong standard when they dismissed count 2. Now, they had the right standard on the other tortious interference counts, but on count 2, again, my recollection was the briefs had already been filed at that point. So again, count 2 is qualitatively different because we had an existing contract with EBS Spectrum as opposed to prospective relations with our customers, which I agree could be terminable at will. They could choose a new provider anytime they wanted. Judges, I've worked kind of my way through, I was all prepared to quote from section 207 and section 206. The one point that I would make in regard to the Federal Communications Act is as follows, and I'm not really a lawyer so much as a historian, but I remember the 1996 Federal Communications Act, and the whole point of it was to open up telecommunications, to get away from the monopolistic providers, to allow more competition in the area, allow people like my client, who's, again, a rural broadband provider, allow them access to the market. And the tenor of that, and I believe that underlies section 206 and 207, is if somebody interferes with their ability to get into the market, if somebody interferes with their right of entry, interferes with their business, which is pursuant to a leased spectrum, which they have bargained for, negotiated, and received, that they have a cause of action. And if the cause of action is unavailable in federal court in this situation, it's almost as if section 207 will have no meaning, because who would qualify? I mean, if you can't stand up and defend yourself, if someone is broadcasting across your spectrum, then basically section 207 at that point really becomes a nullity, as does section 206, because there is no more private cause of action, and everything devolves down to the FCC. And I don't think that was the intent of Congress in 1996. And I don't say that because I was in Congress, I wasn't. But I think if you just read the statute itself and read the legislative history, it's intended to open up telecommunications to small companies. That was the intent. And maybe it hasn't worked out that way, but that was the intent. The other thing I would add, Your Honors, is the state law claims. I do believe that section 414 speaks for itself. It says nothing shall, in this way, shall abridge or alter remedies now existing at common law. I know that this court had the Johnson case in 2015, which was very unusual. Had some very unusual facts. That was the prison case where the family sued the telecom provider because the inmates were using cell phones to contact people on the outside and they coordinated an assault. I think the whole premise of the Fourth Circuit's decision in that case was they looked at the fact that the plaintiff was asking them to jam the signals and say, whoa, hold on, that's the exact opposite of what the Telecommunications Act is supposed to do. It's supposed to promote telecommunications, not inhibit it, and that would be a regulation that was really directly in conflict with federal law. In our situation, we're not asking that to do that. Again, we have a leased spectrum. T-Mobile has a leased spectrum. What we're asking the court to do is simply enforce the rights that have been granted by the FCC, which has to approve all these leases. So I don't think we're in conflict whatsoever. So I know there was a lot of briefing done on that issue, but I think I could synopsize that. Your Honors, I'm pretty much at the end of my time, and looks like you guys are tired of me for a bit, so I'll just come back and rebuttal. Thank you very much.
Thank you, Mr. Peterson. And you have saved some time for rebuttal. And we will turn now to Mr. McLeod, representing T-Mobile. Mr. McLeod?
Thank you, Judge King, and may it please the court. Charles McLeod of Williams & Connolly on behalf of T-Mobile. As we explained in our briefs, there are multiple independent grounds for affirming the district court in this case, and I think in approaching the issues, it's helpful to break Blue Surf's claims into three different buckets. And if I could just briefly walk through those buckets. So with respect to the first bucket, the federal claim in count 1 under section 333, we think the most straightforward way to resolve that claim is to assume, as members of the panel have suggested, that there could be a private right of action under that provision, and then hold that the claim...
As opposed to just flat out reject your argument that there's not, because the statute seems to suggest pretty clearly that there is?
Well, Your Honor, I think actually the statute is less clear than that question suggests. I would point in particular to the North County case from the Ninth Circuit and the Havens case from the Third Circuit, both of which walk through those same statutory provisions and indicate that you need either a predicate determination by the FCC in order to bring a cause of action, or you need a private right of action that is expressed in another statutory provision. And there are other statutory provisions in the FCA, like 270.
So, I mean, we can move. I mean, I'm not going to keep you on this too long because I tend to think you're right on election, but I don't know. I'm just looking at 207, and I don't see a basis for either one of those things in the text of 207.
Your Honor, I acknowledge that the text does suggest that there
It just says any person, they're a person, claiming to be damaged by any common carrier, which your client is, subject to the provisions of this chapter, which it is, may either, they can go to the FCC, or it says, bring suit, which they have, for the recovery of damages for which they have, for which such common carrier may be liable under the provisions of this chapter, which is their precise argument, in any district court. I mean, I understand that other courts have bought this argument, but I don't have any idea how it's got any basis in the statutory text whatsoever.
Well, Your Honor, I think you can't read the statutory provisions in isolation. They have to be read within the broader context of the FCA, which is a statutory scheme that vests primary authority over these issues in the FCC. And that's why...
And yet here I have a statute that says a person can either go to the FCC or to sue.
Yes, but the way that courts have looked at this is you need some sort of predicate determination by the FCC. And I think often this comes up in the context of unreasonable rates or unreasonable practices where there is a rich body of FCC authority. The FCC has made determinations about certain practices through rules and regulations.
But that changes the language of the statute from may be liable to shall be liable, or is liable, or has already been determined by the FCC to be liable. I mean, I promise I will get off this in a minute, but...
No, I'm happy to talk about it as long as Your Honor would like. I think the last thing I would say is, to get back to the point I was making before, it would be, I think, inconsistent with the structure of the statutory scheme to say that a private party can go into federal court and have a district court or a jury resolve these complicated technical issues in the first instance when, since really the inception of the FCA, the FCC has been supposed to be the prime mover in this area. And I think that's the impulse that drives a lot of the circuit decisions.
Sounds a lot like sort of pre-2000 statutory interpretation to me.
I'm not trying to ask the court to go back to the bad old days where we looked at just legislative history and ignored the statutory text. I do think that the courts that have adopted this interpretation have done so for good reasons, common sense reasons relating to the structure of the statutory scheme. Having said all that, as I said before, We don't think the court needs to address that issue in this case because the claim is so clearly barred under Section 207 and the election of remedies provision. If I could just briefly respond to my friend on the other side on those points. First, as a textual matter, we don't read Section 207 to turn on the nature of the request that was made to the FCC. As Judge Agee pointed out, the language of the provision simply says you can go to the FCC or you can go to the district court. And here, Blue Surf has tried to do both of those things. Now, even assuming for purposes of argument that there was a requirement that your request to the FCC included a claim for damages, they have done that here. Judge Hayden's, as you pointed out, they are requesting what we view as classic money damages in the form of compensation for the alleged damages to their network. And so we think that even under the most sort of generous interpretation of 207 for them, the claim would be barred. I would also note we think the claim is barred by the statute of limitations in Section 415B. But again, if the court resolves the case on the basis of Section 207 and the election of remedies, it doesn't have to get into that issue. Unless there are other questions on count 1, I'll turn to counts 3 through 6, which are the claims, the state law claims the district court found to be preempted. We argued in the district court both preemption and the doctrine of exclusive jurisdiction. They are similar doctrines in the sense.
Yeah, I've got some questions about that. As a person whose first law clerks gave him a stop sign that says the words "it's not jurisdictional" on it, are you arguing that this primary jurisdiction doctrine is subject matter jurisdictional?
No. So primary jurisdiction is really a prudential doctrine. It is similar to the abstention doctrines that courts have developed, and it really is just a way to defer to the expert agency on these highly technical issues. Primary jurisdiction, however, is different from exclusive jurisdiction, which is a subject matter jurisdictional doctrine.
How?
Exclusive jurisdiction, and I would point in particular to the Broyd case and the Freeman case from the Second Circuit, is a doctrine that's akin to preemption.
You'll know this better. So are these cases before or after the Supreme Court said stop calling things subject matter jurisdictional that are not subject matter jurisdictional?
Broyd is before. Freeman is about the time when Justice Ginsburg was telling lower courts don't conflate subject matter jurisdiction with the sort of prudential doctrines. But they are grounded in the structure of the statutory scheme, which vests exclusive jurisdiction over technical matters related to the operation of wireless networks.
It just seems bizarre to say that's a subject matter jurisdiction doctrine because that implication of that would be that it indirectly repeals partially 28 U.S.C. 1331, which is a bit weird.
Well, Your Honor, if you don't want to go down the route of exclusive jurisdiction, I think you could focus on preemption in the same way that the district court did. And in particular, that standard for preemption that this court adopted in Johnson, interpreting Section 332C through A, that's a standard under which claims that would obstruct or interfere with the wireless provider's ability to provide a network of wireless service are preempted. We think that that standard clearly bars Blue Surf's claims in this case.
Okay, great. On that,
Do we need to address this exclusive jurisdiction question at all if we go to preemption?
No, Your Honor. You can skip over that question, reserve it for another day, and just resolve the case on the basis of the express preemption in Section 332C through A. And that's the provision that Johnson interpreted and found preemption on the facts of that case. I acknowledge that the facts of Johnson are different than the facts of this case, but I think the legal rule Johnson applied is clearly applicable in this case and resolves the case in our favor because Blue Surf is trying to impose state law duties that are fundamentally inconsistent with the rest of the statutory scheme and with the FCC's role in regulating the operation of wireless networks and managing these sort of network interference allegations.
So sticking with
Is
preemption
your
for a minute.
position different from that of Judge Bennett?
No, we are perfectly happy to adopt the analysis that Judge Bennett did. We framed the preemption issue in two ways, one with respect to exclusive jurisdiction, and the second with respect to the sort of express preemption that Judge Bennett relied on. And we think Judge Bennett's analysis was exactly right on that issue.
Well, I have one question about one piece of the district court's analysis, which is when it said that it's not clear if express preemption is a jurisdictional defense or a non-jurisdictional defense. Do you agree that it's very clear that express preemption is not a subject matter jurisdiction issue?
I agree. I agree. I mean, I think that there is some unclarity in the district court decisions on that issue, but I think
I'm not sure why I'm not sure why this question is unclear, because it feels to me that the Supreme Court and this court have made very clear that whether there's express preemption is not subject matter jurisdiction.
I agree. It goes to whether you can state a claim. That's right, Homer. So it wouldn't change the disposition of the case, and you could still affirm, but we have no objection to you clarifying that it is not a subject matter jurisdiction issue. And finally, with respect to the claim in count 2 for tortious interference, again, we think the district court got the analysis exactly right. Judge Hayden, I'm not as familiar with Virginia law as you are. It sounds similar to the invited error doctrine that I'm more familiar with. The reason we didn't use that label is because we don't think the district court was wrong to apply the standard. It did. There's a reason that Blue Surf articulated that standard.
Right, but we're in federal court now, so tell us why this, it seemed it would be in your interest, but why isn't the argument from the appellants on this particular count invited error?
Exactly, Your Honor. I think you could call it invited error, you could call it forfeiture, whatever label applies. I think it is crystal clear that parties cannot try to change on appeal the legal standard they apply, that they want the court to apply, especially when they argued for that standard. And I would point in particular to JA 580 through 81, which is the portion of the motion to dismiss opposition that Blue Surf filed, where they lay out the standard exactly as the district court applied it. They also applied the same standard in their amended complaint. I think my friend suggested that they had tried to change the standard in the amended complaint. But if you look at JA 653, again, they articulate the standard exactly the way the district court applied. And so to the extent that they are now claiming that was error, I agree, Judge Agee, that would be invited error. And so they can't now fault the district court for that.
Well, I was just asking the question. I wasn't stating a position.
Well, I'll adopt the position and say, if they are going to take the position it was error, then it was invited error. Again, we think that the district court got the standard right, and it's clear under that standard that you need some sort of independently wrongful conduct. And as cases like Macklin from the Maryland Appellate Court make clear, simply negotiating with a party to try to get them to come over to your side and offering them a better deal is not the sort of wrongful conduct that is the basis for a tortious interference claim.
Can I ask about the preemption? So I just want to make sure I understand the theory. So can you explain how, so what I understand they would get as a matter of state law is essentially some sort of order or directive or damages based on T-Mobile's failure to not, quote, stay in its own lane, as it were, its own spectrum lane. Doesn't federal law already require T-Mobile to stay in its lane? So how would it obstruct, burden, or hinder federal law for state law to simply require T-Mobile to do something that federal law already requires it to do?
Well, federal law gives us the authority to decide how best to operate our wireless network, subject to the oversight of the FCC. And what they are trying to do is to say, we have a state law duty to operate our network in a way that is preferable to them. You know, for example, they're saying we can't use certain subframe configurations on our network. We have to use different configurations. They're also saying that we have to, you know, monitor our network to make sure that it's not bleeding over in the way that they suggest. There have been suggestions about, you know, coordinating with them on a more granular level to coordinate potential interference issues. And all of those things are issues where we are operating within, you know, the manner that the FCC permits us to. And so they are trying to impose a state law regulation.
And I guess to the extent that you're not, the FCC can order you to not.
Exactly, and that gets back to kind of our fundamental point here, which is this is ultimately an issue for the FCC to decide. They've had multiple opportunities to go to the FCC, both through their formal complaints that they recently filed and the informal complaint they filed earlier in the case. And so to the extent that there is a problem with the way that we're operating, the FCC has the opportunity to get engaged, to tell us to change what we're doing, but we don't think that they can impose that sort of obligation on us through state law. We think that's preempted.
So this might be a question more appropriate for Mr. Peterson, but as I understand it, the Blue Surf has some sort of an appeal pending at the FCC, and it's just been sitting there for a long time. Is that correct?
That is correct. They have two proceedings currently ongoing at the FCC. One is an appeal from the denial of their informal complaint. They have appealed to the full commission, and that is currently pending, as Your Honor suggested. More recently, they filed petitions to deny the assignment of some of these licenses to T-Mobile. Those petitions are, again, currently pending at the FCC, and they raise the very same interference issues that Blue Surf has been raising throughout this litigation. So those issues have been teed up for the FCC to decide multiple times if the FCC wants to get involved.
All
Have those proceedings, have they had briefs or arguments or anything?
They have not had arguments, but they have had briefing. There have been submissions
Briefing.
by.
So they're, I'm sorry, go ahead.
Yes, there has been briefing. They have put their position in writing. We have opposed their position, and so the issues are fully teed up for the FCC to decide if it wants to get involved in this issue.
And if when the FCC resolves finally one or both of these things, they're subject to appeal to the Court of Appeals?
Yes, they can challenge the FCC's decision in the Court of Appeals.
So we'd have
with
two
respect
more
to-
appeals.
I'm sorry?
So we could have two more appeals of this thing, the way it sits right now.
Your Honor, I'm not sure that it would be two appeals, but they would have an appellate avenue. I don't know just procedurally if they would need to consolidate those, because they do all
Well,
relate.
they may consolidate them, or we may consolidate, but right now there are, what, 3 separate proceedings, 2 in the FCC and 1 here.
There's 4. There's 2 in the FCC, 1 here, and then 1 in Maryland State Court. So there has been a lot of litigation already.
When I was practicing law, we would have characterized this as a lawyer's paradise.
I think many lawyers would say the same thing as well, Judge King. But my point is simply that they will have the opportunity to challenge whatever the FCC does if the FCC comes out in a way that's adverse to them. And the structure of the FCA is that these sort of highly technical questions about spectrum interference, about the configuration of a wireless network are for the FCC to resolve in the first instance.
So, counsel, if you'll remind me, what is pending in the state court? What's the gravamen of whatever's pending in the state court?
In the state court, Blue Surf has filed a breach of contract lawsuit against the schools. That is currently on appeal. The public schools, Salisbury University and University of Maryland Eastern Shore, won in the district court on sovereign immunity grounds, and so that question is teed up to the Maryland Appellate Court currently.
But in the state court, you're not a named defendant.
Correct.
Okay.
So the litigations against us are this federal district court litigation, and then the 2 proceedings in the FCC. And, as I said before, we had briefed these issues to the FCC. The FCC is aware of the interference allegations. The FCC actually investigated the claim of interference earlier before Blue Surf filed its complaint. It made some recommendations to T-Mobile on how to adjust its operations. We followed those recommendations, and we're willing to do what the FCC tells us to do. But again, our point is it's ultimately for the FCC to decide whether we're staying in our own lane or not, as Mr. Chayton's put it.
Have you asked us to hold things in abeyance or dismiss pending resolution by the FCC of those proceedings?
No, Your Honor, we think the best course here is to affirm. Courts do sometimes hold proceedings in abeyance or stay them under the primary jurisdiction doctrine where there has not been any kind of determination by the FCC. We don't think that's appropriate here because Blue Surf has already had and taken multiple opportunities to go to the FCC. The FCC has already rejected once its claims in connection with the informal complaint. And so I don't think that there is anything for this court to stay, essentially. I think the court should simply affirm and let the rest of the FCC proceedings play out as they may. Unless the court has other questions, we'd ask that you affirm.
Thank you very much, Mr. McLeod. We appreciate your work. Mr. Peterson?
I'm sorry.
You're on
Can you hear
mute.
me?
Yes.
Yes, sir. Yes, sir. I realize I have 5 minutes, so I'm going to move quickly, and I may not even need the full 5. I just want to in sort of defense of perhaps myself, but maybe my profession, just, I don't believe we've been overly litigious. I do believe these are actually separate causes of action, and I'll simply say as to the Maryland complaint, that had to do with whether or not that lease had been extended. We had litigation over that, and my colleague is correct. We had won the injunction in Wacomico County in the summer of 2024. The two state universities subsequently got out on a sovereign immunity grounds, on the grounds that there had not been a written amendment to the lease, although they had continued using our services, and we had argued that that essentially ratified an extension of the lease. We did win as to the community college, and we're still transmitting across the spectrum of the community college. So that, for lack of a better term, has been a little bit of a split decision. And again, we have to have this lease so we can serve our customers. That's not damages. That's not trying to put money in anybody's pocket. It's literally allowing us to continue to provide services to folks living in very isolated areas of Worcester County, Maryland, and the Eastern Shore. So that's, again, that's not some type of money grab. That's us trying to stay alive. As to the FCC complaints, the informal complaint, and again, I can't stress this strongly enough, had to do with the awarding of a license to T-Mobile consistent with Auction 108. And Auction 108 occurred, and I'm not an FCC attorney, I'm way outside my lane here. But what I can tell you is we complained about the actions of again, T-Mobile in regard to winning that auction after what they had done to harm our business, harm our network. We complained about that, and yes, Judge Agee, you're correct. We did ask for an award of costs, which would allow us to uplink so that we could continue providing service to our customers, but we never sought damages. And I think if you look at Section 207, it talks about seeking damages, and we never sought damages. The only case in which we sought damages is this one. The other one is the petition to deny the assignment. Again, T-Mobile has come in, they've essentially bought out the spectrum from the universities, which is our lifeblood. It would be essentially taking away our oxygen, and they are seeking assignment. And again, we filed a petition to deny that assignment. We have every right to do it. You know, we have a right to protest, and the FCC is going to do what they do. None of those actions have anything to do with the actual loss of business that we suffered. In 2021, we had 1,200 discrete customers on the Eastern Shore of Maryland. We were growing. We had all sorts of federal and state contracts that we were stepping into. It was during the middle of COVID, and people were relying on rural broadband. And that's when we got hit by this interference, which, again, virtually crushed our business. And all these other actions are essentially rearguard actions to try and stay in business. My client has a right to stay in business, but even if he does stay in business, that will never remedy what happened to us when effectively, like I said, we lost half our customer base and really lost any momentum that we had to grow the business and fulfill the vision that we had. So that's essentially what I had. In regard to the tortious interference count, I feel like we've kind of beaten this to death. Again, all the briefs were filed before we amended the complaint. In the amended complaint, we did lay out the standard for tortious interference with an existing contract. And in the next couple paragraphs, and I just checked it, we did talk about use of improper methods, but that was not to say that we hadn't stated the standard for a tortious interference. We just said there also were improper methods in case the court wanted to look at that. Again, it was an existing contract. We pled it as such. The court can do what it wants, but I just feel at the end of the day the district court used the wrong standard, and we would have briefed it, but for the fact the briefs had already been filed. So I don't think we were in any way negligent in that respect. As to Section 207, I think Judge Heitens, you're exactly correct. It says what it says. We've all read statutes. I've written statutes, and it's a pretty clear grant of authority that any person can come into a federal court and file an action. I understand all the preemption arguments. I've looked at Section 333. In fact, I have it in front of me right now. Excuse me, Section 332 regarding mobile services. I have it in front of me right now. I don't think anything we're asking the district court to do would in any way interfere with a duty or obligation under Section 332. So I'm coming to the end of my time. Gentlemen, I appreciate your patience on a very chilly day, and I wish you Godspeed.
Thank you very much, Mr. Peterson. I want to commend both the lawyers on the you've very ably presented the positions of your clients, and that's legal work well done. As I said earlier, we were supposedly in the tan courtroom. If we were in Richmond, we would leave the bench at this point and come down into the well of the court and greet counsel, as we do in every case. We're not able to do that today, but we'll hopefully get you back to Richmond at some point, and we will be able to meet you in the well of the court. That said, we will take this matter under advisement, and unless either of my colleagues need a break, we'll proceed to the next case, Madam Clerk.
Thank you very much.
Thank you.
Thank you, Your Honor.
Taking a break?
Judge, the attorneys are ready.
In the second case, number 2469, the United States versus Taylor. Mr. Newton.
Good morning. May it
for
please the court.
appellant. Mr. Newton, nice to have you here.
Thank you.
We
Good
appreciate
morning.
your work.
Thank
We
you.
know your court. We honor that. Go right ahead, sir.
Thank you. May it please the court. There are many issues and many sub-issues in this case, so in my limited time, I intend to address initially at least, the issues that most broadly affect the three convictions: the due process perjury claim and the ineffective assistance of counsel claim related to the conduct of counsel during trial as opposed to related to insufficient evidence issues. After I initially address those issues, if I have time left, I will turn to some of the insufficient evidence issues. I'll begin with the due process perjury claim. Before I turn to the merits of that claim, though, I want to briefly address the government's erroneous argument that this claim was waived by not having been raised on direct appeal. The claim could not have been raised on direct appeal. The critical evidence in the case, that the FBI 302 documents concerning officers Hendricks and Ward, that the pretrial statements they made to the trial prosecutors, co-defendant Wayne Jenkins' plea agreement, and an excerpt from a 2023 book by lead prosecutor Leo Wise, none of that was part of the record on direct appeal. In addition, the record did not contain testimony from the trial prosecutors. Obviously, that's very important with respect to this claim, and that hasn't happened, of course, because the district court denied my request for an evidentiary hearing.
Well, weren't the two witnesses, Ward and the other one, they were cross-examined on those statements, weren't they?
They were cross-examined about very narrow aspects of those statements. Trial counsel, and this is also related to my ineffective assistance of counsel claim, trial counsel failed to walk them through the most important, flatly contradictory part of their pretrial statements to the trial
Well, here's a
process.
question. So in an attempt to get a lesser sentence, you talked about Detective Taylor called out on the radio that somebody was running from the back of the house. That was the hoax that we came up with. So when you told them they weren't able to catch the person, that was just a lie. Correct. And then they go on to talk about a little bit further, and they again say that was part of the lie too. Yes. What is it exactly that you say was missing here?
So this is what should have happened. Trial counsel should have gone over with both Ward and Hendricks. They should have said, okay, so in your pretrial statement, you said the following: there really was a chase. Multiple officers, not just Detective Taylor,
Right,
chased.
but Ward's just said under oath, yeah, I lied about all that. I'm at a loss to understand what it is you're trying to get at.
No, what he said he lied about was lying to the neighbor that this had happened, that this was a hoax, this was a ruse. What did not happen was a
No,
very...
he's asked specifically. When you told them they weren't able to catch the person, that was just a lie and not actually true. Correct. And so you told them that Detective Taylor was not sure if the person came out of the house. That was part of the lie too. Yes. I mean, he's already been impeached. Tell me what it is that you say would have been different?
The trial counsel should have gone word by word with both Hendricks and Ward with respect to what they said to the to the prosecutors before trial, and among other things, saying that Detective Moore had seen a person trying to break into the house, which is why they felt the need, there were exigent circumstances to get into the house. There was absolutely no indication in the pretrial statements that this was a fictitious person who was running. They were creating this to make the neighbor believe they had exigent circumstances. In their pretrial statements, they were
Sorry, can you just help me understand? I thought this was a due process issue, but now we're hearing what counsel should have done. I literally just want to make sure I understand. Are we talking about an ineffective assistance of counsel claim right now, or are we talking about a due process, knowingly presenting perjured testimony claim right now?
both. So the Supreme Court in Glossop said in 2025 that it does not matter whether or not a defense lawyer should have used this stuff at trial effectively. That's irrelevant. The burden is on the prosecutor. That's said at Glossop at 604 U.S. at 252. So it relates both to my ineffective assistance of counsel claim that they failed, the trial counsel failed to go at these two critically important, most important witnesses for the prosecution about their flatly contrary statements to the trial prosecutors before trial and their statements at trial that this was all a hoax or a ruse. So
okay,
it relates to both.
Can I take those one at a time, because it came up during your response to Judge Agee. So to the extent the argument is that defense counsel should have asked more questions, could you respond to Judge Agee's point of like, and Judge Agee's like, you've already impeached them, and you say, but you should go line by line, and then I start to go, this does not sound like Strickland prong one. When we're asking whether defense counsel should have either just taken the admission that they're lying liars, or whether we should have gone over in loving detail all the ways in which they're lying liars, strikes me as a classic Strickland prong one. It's almost impossible to say that there was deficient performance, because that's a tactical judgment at which different lawyers could reach different conclusions. So, well, I guess I'd invite you to respond to that, and then, yeah, so could you respond to that? I'm very skeptical of how that could be deficient performance under Strickland 1.
Well, here's the problem, and the district court engaged in this problem, or committed this error. We never heard from the trial prosecutors because I never got my requested evidentiary hearing. We don't know what judgments they made or didn't make. Maybe they did not read those pretrial statements carefully enough. Who knows? We just don't know. And you have to look at the record in the light most favorable to Mr. Appellant Taylor. You've got to also...
But counsel, what difference does any of that make?
If the jury believed, and it's not just, by the way, the limited questioning, there's more to it. So in Leo Wise's 2023 book, which is part of the record, he said that the son of Maurice Stevenson was sitting on the porch when the cops pulled up. The Ward and Hendricks were like, no, there was nobody on this property. It was a fictitious person. They also, in Ward's testimony, he specifically said, Detective Moore, this is in his pretrial statement, Detective Moore saw somebody trying to break into the house. No one talked about that at trial. That's completely contrary to their version at trial, which was, this was completely a hoax. We didn't have any reason to believe anybody was breaking in the house. We just wanted to do a sneak and peek and see what was in Maurice Stevenson's house, and the neighbor was watching us, and we didn't want the neighbor to later tell somebody that they broke into the house, so they had to invent a hoax or a ruse. Another example of something trial counsel didn't get into. Ward said, not only did Taylor run after, this is in his pretrial statement, this real male, this non-fictitious male, the son of Maurice Stevenson, according to Wise's book, didn't run after him by himself. He was joined, it was Ward, joined by Hendricks and Ward trying to run after the male. So it wasn't just Taylor who supposedly engaged in this hoax. It really wasn't a hoax. All three of those officers ran after him. So there is a significant version of events told to the prosecutors before trial compared to the version that was given at trial.
And so what's the, if you've adequately answered Judge Hyden's first question, we want our counsel, particularly court appointed, to be zealous advocates, but when you accuse the prosecutor of suborning perjury, that's pretty serious. And that's basically what you've said in your brief.
Your Honor,
What's the proof that there's suborning of perjury here?
the government at trial took the firm position in their closing argument and in their questioning of the witnesses that there was never anybody on the property. This was 100% a ruse, 100% a hoax. It was completely made up for the purpose of creating exigent circumstances. That was argued by the prosecutor in closing arguments. It wasn't just the witness saying it and the prosecutor just let it go. They embraced it at trial. In Kyles versus Whitley, the Supreme Court at 514 U.S. at 443 dealt with a somewhat similar situation where there was pretrial statements that were flatly inconsistent with the trial testimony. And the Supreme Court said these developments would have fueled a withering cross-examination, destroying confidence in the witness's testimony, and raising a substantial implication that the prosecutor had coached him to give it. So you have to look at the evidence in a light most favorable to the appellant, because we didn't get a hearing. So that means looking at the allegations in the 2255 motion, as well as these things such as the pretrial statements, looking at it in a light most favorable, I'm entitled to a hearing. The judge should hear from the prosecutors. The judge should hear why these stories changed so significantly.
We review that for abuse of discretion.
Well, the case law occasionally says abuse of discretion, but when there is a genuine issue of material fact that the district court was presented with when viewing the evidence in a light most favorable to the movement, it is de novo in terms of deciding whether there should have been a hearing or not. That's black letter law about summary judgment. I will now turn to the ineffectiveness claim. Well, let me quickly say, the standard for prejudice, the standard for materiality, the Supreme Court in Glossop made it very clear in 2025 that the government has the burden to prove beyond a reasonable doubt that the perjured testimony did not contribute to the verdict. It doesn't even have to be something that directly supported the verdict. The Supreme Court was very clear in Glossop about the incredibly difficult standard the government faces with respect to proving that the testimony did not contribute in any way to the verdict. These two witnesses were very important witnesses. I also should add regarding another officer, Officer Graham. A part of my ineffectiveness claim should also be relevant here because it also could potentially be false testimony. That was my expert witness who went through the purported transcript of what was supposedly said in an undercover recording, and she said what the officer claimed at trial in leading questions based upon a transcript prepared by the government was never said. We don't know because we didn't get a hearing about what the actual
Well, the
truth is.
trial counsel basically made that argument, and the jury heard it.
No, trial counsel said it was indecipherable. Trial counsel did not say that it was the opposite of what was in the transcript.
But the jury heard it, and they could make their own decision on what they thought it meant.
Your Honor, without an expert witness to enhance the recording, the jury could not have made any sense of it. That's why I got an expert. That's what trial counsel should have done. That would have also called into question the integrity of the prosecution, because according to my expert, and you've got to believe her.
Yes, the defense lawyers. You're coming before us and purporting to be an expert in all this stuff, and you weren't even there.
Your Honor, I'm not purporting to be an expert. I'm pointing out to my expert's report.
You're undertaking to testify before us about all this that you were not involved in. You got in this thing last year.
Your Honor, I'm not trying to testify. Your Honor, I'm not trying to testify. Your Honor, I'm simply pointing to what my expert said, looking at the evidence in a light most favorable to appellant, which is the required standard of review. What the jury heard was indecipherable, which is why the prosecutor created a transcript. I have an expert who's never had a chance to testify who says that's not what was said.
Sorry, could I go to you were trying to move to your ineffective assistance of counsel arguments, and I have one sort of question. These are about ineffective assistance of appellate counsel. What is your best case where a court has found that appellate counsel who actually filed an appeal was ineffective on appeal. Like, virtually all, if not all, of the cases I've seen where appellate counsel was held ineffective were cases where appellate counsel literally didn't file an appeal.
There are cases out there where there have at least been remands for.
Okay, what's your best one?
There's a Seventh Circuit decision, let me see if I can find it, in which the court discusses the standard. The best case is obviously Smith versus Robbins. The Supreme Court said that if you have a case where stronger issues are omitted and there's a reasonable probability those issues would have prevailed, that is a showing of ineffective assistance, applying the Strickland standard.
So let me ask you that. So appellate counsel raised 9 issues on appeal. Are you saying they should have raised more than 9 issues, or are you saying they should have cut some of the issues they raised and to add the issues you now claim they should have made?
The latter. They should have cut virtually all off.
How is that, again, not core Strickland prong 1, deciding which issues to keep and which issues to lose and which ones you think have a better chance and which ones you don't? This feels like core Strickland prong 1.
Well, Your Honor, Strickland requires deference to lawyers, no question about it, in their strategic decisions, but it's not blind deference. This is an objective standard. And when there are issues based upon the existing legal landscape that are stronger than the issues that were raised, and those issues have a reasonable probability, had they been addressed in a normal direct appeal, then that is ineffectiveness under the Smith versus Robbins test. So I want to talk brief. Oh, I've run over. I'll reserve the remaining time for rebuttal.
Thank you very much, Mr. Newton. Ms. Nunez?
Yes, Judge King. Good morning, and may it please the court, MJ Kirsch-Munoz for the United States. A jury found Marcus Taylor guilty of racketeering and robbery after he and his gang of corrupt police officers violated the trust of the citizens they swore to serve in almost countless ways. 8 years and at least 4 courts later, he stands here offering a host of insufficiency arguments, claiming that no rational juror, not a single one, could have convicted him on the evidence presented. These arguments are procedurally defaulted, but worse than that, they are impossible to swallow on the merits. The government respectfully asks that this court affirm the jury's well-founded guilty verdict. Unless your honors have a preference otherwise, I'd actually like to start with where Judge Heitens left off with my colleague on the issue of procedural default. And I note that on appeal, Mr. Taylor has abandoned his claim of actual innocence. So his only hook for raising these belated insufficiency claims is his contention that appellate counsel rendered ineffective assistance. But Mr. Taylor cannot meet the ineffectiveness standard here, which sets a particularly high bar when the argument is that his appellate counsel, though having filed a merits brief raising 9 different claims of error, was ineffective for having failed to raise the particular claims of error that he now wishes had been asserted. This just doesn't fly, absent of showing that the ignored issues are clearly stronger than those presented. And Mr. Taylor does not meet this standard. He barely even tries. He spends most of the brief arguing that his claims are merely meritorious, but that there's significant daylight between, finding that claims are meritorious and finding them so much so clearly stronger that counsel's failure to raise them on direct appeal amounted to constitutional ineffectiveness. And so, this is a very easy way for this court to reject the insufficiency claims, which, as even Mr. Taylor admits, he did not make on direct appeal. There's no reason necessarily to get into the merits here.
So can I ask you a question about something you say in your brief about harmless error that strikes me as wrong, and I'd like to give you a chance to tell me why it's not? So you argue that as long as we find sufficient evidence to support one of the convictions, any errors to the remaining 2 is harmless because they're the identical, you know the line from your brief, identical and concurrent sentences on the others. Identical and concurrent life sentences. Hasn't the Supreme Court and this one both said that's wrong because as long as each count has different special assessments, it's not harmless error to be like, oh, it turns out you shouldn't have been convicted on count 1, but that's no big deal because you have life on count 2, except count 1 also requires you to pay money. So doesn't that not work?
Your Honor, I will not, rest on the harmless error argument that was made in our brief. I do think, especially at the stage that we are at now, it is, a part of the calculus at least to note that.
So is that a soft concession that what you said in your brief is just dead wrong because it's inconsistent with what the Supreme Court and this court have both said?
I am reluctant to make any such concession. I will, however.
Are you telling me that Ray versus United States, 481 U.S. 736, 737 doesn't directly reject that argument?
I have not read that case, Your Honor, and I apologize. I'm not sure if I can directly answer your question. I will just note again that I will not, rest the government's arguments on harmless error in this case. Again, we believe that the insufficiency claims here are clearly procedurally defaulted, and there's no reason to entertain the merits of them now.
So can I ask you about the district court's law of the case holding, which strikes me as deeply dubious? So on the direct appeal, did anyone advise the panel that count 3 might not encompass the traffic stop robbery? Like, did anyone say that on direct appeal?
I am not aware of whether anyone had said that, no.
How can the panel have possibly decided an issue that no one raised before that panel?
I'm not sure whether it was raised. I honestly can't speak.
Well, let me represent to you that based on my research, no one did. So assuming that it was never raised before the panel, how could it possibly be law of the case on that issue?
If it was not raised before the panel, I would say that it is not law of the case. However, I think that it was within the jury's, province to.
No, I know, but the district court rejected it on law of the case grounds, which strikes me as wrong, and I'm asking you why it wasn't wrong for the district court to reject it on law of the case grounds.
I think the district court did assume it was law of the case, but then went on and said, like, even if it wasn't law of the case, I would still find the convictions to stand based on the evidence of the robbery, or the van robbery, I should say. And so I'm not sure that the district court, hung its hat entirely on the peg of law of the case.
So you're arguing now on that point that there's an alternative holding by the district court that's not dependent on law of the case?
Your Honor, I believe that there was an alternative holding there. I believe that, yes, the district court initially said, yeah, this is law of the case. Count 3 can rest on the van robbery because, the Court of Appeals said so on direct appeal. But I believe it, unless I'm mistaken, and I don't think I am, but please tell me if I am, it goes on to say that even if it weren't law of the case, it would still find that the van robbery was sufficient on which to convict on count 3. And, the government believes that is certainly correct.
In your view then, on this particular point, we can just ignore that law of the case part and look only to the alternative holding? It's not a trick question. It's just trying to narrow this down.
Yes, I think that you can look at that alternative holding, and what's more, that alternative holding is correct. The jury was entitled to find that the van robbery constitutes Hobbs Act robbery for purposes of count 3. The evidence was more than sufficient that the money was taken from Stevenson's van within his presence by use of force or threat of force, and so that is classic Hobbs Act.
Theft out of the safe?
I'm sorry, Judge King, I didn't hear that.
I'm sorry also, but are you discussing you're talking about count numbers and things? I'm not familiar with that, but I know about the $200,000 theft from Stevenson's safe, where they stole the $100,000 of it, turned the $100,000 into the other. You
Yes.
hear me there?
Yes, I did. And so, yes, that is what was charged as part of count 3, which is the Hobbs Act robbery count. And of course, Mr. Taylor makes the argument that this reference to $200,000 necessarily means that the jury had to find, Hobbs Act robbery from the house robbery rather than the van robbery to convict on count 3. And the government's position is that that's not necessarily true. The reference to $200,000 is not as telling as Mr. Taylor seems to think it is. There was $200,000 in the safe, but only $100,000 of that was actually stolen. There was also a watch valued at $4,000, and then of course we have the $6,500 taken from the van. So the $200,000 reference in the indictment with respect to the Hobbs Act robbery is not nearly as telling as I think Mr. Taylor would have it. But certainly the house robbery equally suffices on which to have convicted Mr. Taylor of Hobbs Act robbery.
So can I thank you for the clarification about the district court's alternative holding, which I agree. I'm now seeing, I pulled up the language and I've seen the district court's alternative holding, which just opens up another can of worms for me though, because the district court's alternative holding is based on the fact that Ms. Holloway was robbed, which at that point raises the what does this indictment charge question, right? So could you address that? So as I read the district court, I'm just looking. The district court says, were the court to reach the issue the Fourth Circuit did not address it, it would find that the robbery of the money from Mr. Stevenson's home also constituted a robbery of Ms. Holloway. And then you've run right into your friend on the other side's argument that the indictment doesn't charge a robbery of Ms. Holloway. So could you address that?
Sure, Your Honor. So, Taylor's sufficiency challenge on this count is based on the premise that the jury could convict only if the house robbery in this case had Maurice Stevenson as the victim. But that premise is false. The Racketeering Act 8 allegations in the indictment are agnostic as to the victim. And the district court's final jury instructions are also agnostic as to the victim. They did not require the jury to find Stevenson or any particular person was the victim of the house robbery.
Is it your view that parenthetical under count 8 is a caption? What do you think that parenthetical is?
I think at worst it's shorthand. It's a mnemonic, memory aid. This is the robbery of Maurice Stevenson's house. This is the robbery of Maurice Stevenson's van.
But that's not what the parenthetical says. It says the robbery of AS. I understand who we know that is, but it doesn't say robbery of his van. Well, first of all, you can't rob a van, right? You can only rob a person. That's not how robbery works.
That is correct, Your Honor, and I'm sorry that I misspoke. But that the captions just simply do not alter the substantive allegations of the count. I mean, if you
What's your best authority for that proposition?
We cite a Ninth Circuit case in our brief at page 21, United States versus Lopez from, again, the Ninth Circuit, a 2021 case.
So if we're jumping to the Ninth Circuit, can I assume that means this court has never held that?
I have not found any case in this circuit to have held that. I did, however, in my pre-argument review, I found another case that supports the government's position here. That case is United States versus Ansaldi, a Second Circuit case from 2004. The number is 372 F3rd 118. And in that case, the court held that the indictment described defendants trafficking in detail and then referenced those events with the shorthand designation of narcotics trafficking. But the term narcotics trafficking unambiguously referred to the sale of a particular narcotic, given the detailed allegations in the body of the indictment. And that is essentially what we are suggesting here, is that the captions, again, do not alter the substantive allegations of the counts. And of course, if you look at the indictment, page 99 of the joint appendix, it actually provides 6 different modalities for how Racketeering Act 8 could have been committed. Now, the first 3 modalities do name OS as the extortion victim, but the last 3 modalities, the robbery modalities, are entirely silent as to the victim. And the same is true with respect to the allegations on page 69 of the joint appendix. They describe the robberies, how they unfolded, but are again agnostic as to the victim. And so, it is the government's position that the jury was entitled to convict on counts 1 and 3, but again, since we're speaking only of the Hobbs Act robbery, based on the robbery of Mr. Stevenson's wife, Kiona Holloway. The indictment, again, did not specify any particular victim. neither did the court's final jury instructions. If there are no other questions on...
Let me ask you just theoretically, if Ms. Holloway had not been at the house, would there still be a robbery?
I think, no, if she had been just, completely absent from the house, I think that there would have been no robbery. She wouldn't have been in a position to prevent the taking. But of course, she was at the house. She was forced on the couch, forced to remain on the couch by the police officers from they were exploring the house looking for the money and drugs and other paraphernalia to steal. At some point, I will say she was kicked out of the house, on pain of, on the threat of arrest, I should say. She testified that she was afraid she was going to be arrested if she didn't do exactly what the officers said. But she remained directly outside the house, parked in her car, watching the front door of the house. And so if she, of course, had not been expelled from the house, she would have been able to reach the items and prevent their taking. She would have stayed inside and prevented any takings had she not been subjected to force or threats. So, again, this is a classic case of Hobbs Act robbery, even if we, assuming, as we should, that Kiana Holloway was the victim and not Mr. Stevenson, who was in custody at the time. I will, I think, use the remainder of my time to just discuss a little bit this idea of perjury. Now, as the district court found, the alleged inconsistencies between what Ward and Hendricks...
As I understand opposing counsel, he's just not alleging perjury, but he's alleging that the trial prosecutors suborned perjury, which is a fairly serious allegation to make.
Correct, Your Honor, and I'm sorry if I misspoke. But,
Well, no, I mean, it's just, I think it's two things. It's the perjury of, I guess, Ward and Hendricks and maybe some others, but that also the trial prosecutors aided and abetted the perjurious testimony.
Correct. And, as your question underscores, this is an incredibly serious charge. And frankly, there's no basis in the record to find that the prosecutors suborned perjury. And to prevail on such a claim, Mr. Taylor must demonstrate that the testimony was false, that the government knew, of course, that the testimony was false, and that there's a reasonable possibility that the false testimony could have affected the verdict. And I would submit that Mr. Taylor has failed on all three prongs of that test. I mean, the testimony wasn't false. There may have been minor inconsistencies, but, according to a 302 report for Ward's proffer in April of 2017, he thought that Jenkins was saying that a person had run from the house so that he would have probable cause to get a warrant. And according to the 302 report of Hendricks's May 2017 proffer, an officer called out over the radio, "Hey, somebody is running from the house." But Hendricks did not indicate whether he saw the person himself. And so, frankly, this is not, materially different from what both Ward and Hendricks said at trial when they're on the stand. And of course, as Your Honor again suggested by virtue of the question, there's simply no suggestion to support the very serious charge that the government knew the testimony was false and that they, aided and abetted the perjury. I see that I have about 3 minutes left on the clock, but I'm happy to sit down, as it were, if the panel has no other questions. Wonderful. Then I will cede my remaining time, and I respectfully ask this court to affirm.
May I proceed?
Thank you very much.
May I proceed, Your Honor?
Thank you very much. Yes. Mr. Newton, you'll take 5 minutes.
Thank you. I want to go back to this, of the perjury.
Are you accusing the prosecutors of suborning perjury?
I am saying the following. I think a rational fact finder, after an evidentiary hearing, could conclude that. All right? I did not get a hearing. This is what the record showed.
The rational fact finder could conclude what exactly?
Looking at the statements given that are quoted in my brief that are part of the record, the statements that Ward and Hendricks gave to the trial prosecutors, combined with Wayne Jenkins's plea agreement signed by the trial prosecutors, combined with Leo Wise's 2023 book, all of that, when you compare that to what to what Hendricks and Ward testified at trial about the ruse, the hoax, whether there was really somebody at the back of the house, whether there was somebody trying to break into the house, whether somebody ran away and one or more officers, most importantly, Appellant Taylor, chased them, they are completely contrary. Now, whether defense counsel tried to cross-examine them, different issue. As I noted in Glossop, the Supreme Court said, it doesn't matter what defense lawyer doesn't do. What matters is, did the trial prosecutors know these people were saying something that wasn't true? If you carefully look at the statements that Hendricks and Ward gave to the trial prosecutors, saying this really happened, we really chased somebody, and combining that with Jenkins' statement that Maurice Stevens' son was on the property, both under oath. Hendricks and Ward said repeatedly, nobody was on the property. This was all completely...
So the statements that are on these FBI forms, that's what you're talking about, correct?
Combined with Wayne Jenkins' plea agreement signed by the two trial prosecutors.
So the statements were not signed by the witnesses, is that correct?
Correct, Your Honor. But remember, you've got to look at...
And they were not made under penalty of perjury.
Well, it's a 1001 violation to lie to a federal agent and to lie to a prosecutor. You've got to look at...
The 302 statements of the FBI agents are the statements of the FBI agents. They're not the statement of the witness. They're not. The witness testimony came from the witness stand.
The witness
believed the jury, credited by the jury.
The witness's statements to the jury were under oath. The witness's statements to the trial prosecutors are... I'm sorry, Your Honor.
Go ahead.
The witness's statements to the trial prosecutors recounted in FBI 302 forms must be considered at this juncture to be accurate and what they said.
So that is the FBI agent's statement.
Of what these two men said. Of what these two men said. For purposes of this procedural posture where we haven't had a hearing, you've got to look at the evidence in a light most favorable to Mr. Taylor, and that includes assuming what's in those 302 statements are true and accurate about what Hendricks and Ward told the trial prosecutors and the FBI agent prior to trial. Compare those two. They are diametrically opposed about the hoax, the ruse, the chasing the boy. Factor in also my expert witness's report about there being absolutely no statement that she could pick up consistent with what that transcript created by the government. Read Raymond's testimony. They're leading questions by the prosecutor. So the transcript says blah, blah, blah. Is that what was said? Yes. Again, in a light most favorable to Mr. Taylor, I have made out a sufficiently colorable perjury claim. This is the reason we have hearings. Let the prosecutors have a chance to explain. We've never had that opportunity. There is a colorable claim.
Your point is entitled to relief because you made out a perjury claim or a subornation of perjury claim.
Well, the way the Supreme Court refers to it is a prosecutor either elicits it or fails to correct it. Same difference. And it can be misleading or an outright lie. Same difference. I am entitled to a hearing at which the two trial prosecutors may testify, in which I may question also Hendricks, and I may question Raynham, and I may question Ward about the evolution of their statements from the ones recounted in 302s. If they want to call the FBI agents and say, oh no, this was all a mistake, fine. I've never had a chance to do any of this. All I'm asking for is a hearing on this very important claim.
The only request you're making today is for remand for a hearing. Is that correct?
That is absolutely correct. I just want a hearing because I believe I've made out a colorable claim. I'm out of time. Thank you.
Thank you, Mr. Newton. And we, Judge Agee mentioned we know you're court appointed, and we appreciate your work. And we'll take the matter under advisement. We also appreciate, Madam Prosecutor, your work on this matter. We'll take it under advisement. And if we were in Richmond, we'd come down to the well of the court in the tan courtroom and greet you personally. But we're not there. We'll get next time. We'll be able to do that. And that being said, I'd like to take a brief break if my colleagues will approve that.
Yep,
And,
I agree.
Madam Clerk, we got a majority, so.
I certainly agree too.
This honorable court will take a brief recess.
Thank you, Madam Clerk.
I'll place the attorneys in the waiting room. Thank you.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
We're ready for, we're going to call the third case, which is Kalos versus the Cedar Fair Southwest. The appellant is represented by Mr. John Parker. Mr. Parker, good to have you with us.
Good morning, Your Honor, and may it please the court. I go by Jay Parker, but I am here representing the plaintiff appellant, Mr. Michael Kalos. I'd like to start by not going through a unnecessary rehashing of the procedural history or facts, but actually try to focus us in on actually what the hazardous condition was in this case, because I think this is where the district court got majorly thrown off in the beginning, and I think opposing counsel did a very effective job of briefing this and set up a straw man about what the hazardous condition is in this case, and it set me and the district court chasing down rabbit holes about whether or not my client, Mr. Kalos, about whether his conduct in this case matched the inspection that Carowinds, which is the defendant, asked for. That's the name of the amusement park, Carowinds. Cedar Fair is the defendant's actual name. But it set us off chasing down these rabbit holes of whether or not what he was doing was within the scope of the work order, and that's not what the duty analysis is in this case at all.
Why not? If they have a written contract for a visual inspection, what other duty is there?
So the duty, and this is what we've argued, the duty is the duty that it's incumbent on any property owner to warn of hazardous conditions on the property. And so this wrinkle that was thrown into here with having an independent contractor there working, there's two scenarios that can occur when you have this independent contractor coming on to perform work. One is you have a pre-existing
And it's not just any independent contractor, it's an independent contractor who holds themselves out to be an expert in this particular field.
That's correct.
This is not a case where the Carowinds goes down and picks up a day laborer and brings them to the amusement park and says, here, go up and do this. Because you've got, it would seem like to me, very different duties depending on the context.
Sure, and that could be part of the comparative negligence analysis. That could be part of the open and obvious analysis, but those weren't actually part of the district court's reasons for its order. And the reason was duty, and the duty analysis is a lot more straightforward than that.
Right, but duty is a necessary prerequisite. I mean, if you're going to recover in tort, you have to establish the duty before you ever get to a question of causation.
Sure, and I'm solely here to talk about duty right now. And so before you determine, the whole duty analysis starts with this in that independent contractor context. You have to decide two things, and this is abundantly clear from all of the case law, from all the jurisdictions that you can look at on this. There's two things. Was the hazardous condition pre-existing the invitee's presence on the property? You have to look at it. One, was it that? Or two, was the hazardous condition created by the invitee's conduct on the property? The district court, because of this argument about the scope of the work, got totally wrapped into the idea that this hazardous condition was created by Mr. Kalos. And it ignored evidence in the record that this hazardous condition existed in this machinery and on this property from the moment that that wind seeker was put together on that property. And this is what we've defined as the hazardous condition from the get-go. It is a pinch point in a shiv within that machinery. And this is my partner and boss who's watching me argue right now. He does extensive work in the products context. He'll tell you this hazardous condition, a pinch point, hazarded machinery that's unguarded, someone's hand getting stuck in it, this is one of the most common mechanisms by which someone is harmed by a product defect. Okay? So we're not talking anymore about whether or not Mr. Kalos created this condition. We're talking about whether this condition pre-existed his invitation onto the property. There is evidence in the record that it most certainly did.
So then, so let's assume that we agree with you on all that. I guess the next question, I mean, there's obviously lots of questions about comparative fault and assumption of risk. But I take your point, that's not the ground on which the district court ruled. But to the extent we're defining the pinch point as the dangerous condition, how is it not open and obvious? I just sort of feel like, I mean, I'm not a person who works in, like, I just feel like the dangerous condition is that when this metal wire reaches a point of the top of the pulley where it starts to compress in, if something gets up there, it's going to be really dangerous and bad. Why isn't that an open and obvious danger?
So again, you'd have to look at, I mean, a great place to start is restatement section 343A of defining what open and obvious means.
Yeah, and I guess let me just say, one of the cases that's cited in the brief is, if I ask somebody to go up on my roof, I don't have to warn them that roof is really steep. If you fall down, you could definitely fall off it, and if you fall off it, you'd probably get hurt. And I don't have to say that because anybody who literally looks at a steeply slanted roof knows that. And why isn't the analogy, anyone who looks at this gigantic pulley mechanism knows if something were to get caught up at the top of that pulley, that would be real bad. It feels pretty analogously obvious.
So what the restatement says and what the case law says, it's not whether or not the hazardous condition is clearly visible, right? Anyone can look there and see it. Nothing's hiding it. It's not hiding behind anything. It's not a hidden trap door. But the question is whether a reasonable person in the injured person's shoes, given all the circumstances, attendant circumstances, whether they would have appreciated the danger created by that, right? So sloped roof, obviously anyone knows, you look at a sloped roof, I can slip and fall off of that. That's just common knowledge. I would agree with that. Now, under these circumstances, again, we have to look, this is summary judgment, so we have to look for evidence supporting, is it possible that a jury could find that, you know, a reasonable person in Mr. Kalos's position wouldn't have known that would have seen the shiv and known it was there, but not known it was dangerous? And there is evidence in the record supporting this. There's evidence that the way he was trained was to touch this wire rope. The way that he was trained gave no warning whatsoever about this shiv. And so he's going under this economic compulsion to be there working with the training he's been given, the training that would have been given to any reasonable person in his position.
Right.
In his
Well, why
shoes.
would Carowinds have known that his training was defective? I mean, that would seem to fall back on his employer, not on Carowinds, because the employer has helped itself out to Carowinds as being an expert in this, and they have, either through this particular entity or the entity that they subcontracted with, they have a history of performing these acts.
I mean, I think that's very valid, and that's relevant to an empty chair defense or a comparative negligence analysis. But again, we're talking about duty, and what's getting conflated here is just like take out the independent contractor label. Because the thing is under the common law, once you determine that it's a pre-existing hazard that caused injury to the invitee, the subcontractor, that subcontractor, independent contractor label does not matter at all. It is completely irrelevant. When all that matters is now you are in a typical premises liability analysis of duty, which is, did the property owner have
why would
action?
Carowinds ever even bother to have a contract with these folks? And they represent, you know, we're gonna do all these things and we have this expertise. I mean, I just don't see how you get to kind of elide over duty by moving off to some sort of comparative negligence argument.
I'm not. I'm trying to draw us back into duty. And the thing is that what we're discussing, well, how are they supposed to know that he was gonna do this? Okay, you could make, in a normal vanilla premises liability context, you can make that same argument about the plaintiff and say the defendant, well, how did he know he was gonna step into the trap door? How was I supposed to know he was gonna grab that live wire? I mean, but the duty analysis has nothing to do with the plaintiff's conduct. If you look at our common law, Wilson versus Duke Power, this is the case where the guy is a subcontractor, he goes up on the roof, he's doing roof construction, roof repair. The property owner knows there's a high tension, high voltage wire going right over the property. And the sub is working on that property. The power line, the electric power line is open and obvious. He backs up and either the electricity arcs to him and hits him or he touches it. And the appellate courts in South Carolina have said the duty analysis in that is the exact same as if a customer slips on a grape in a grocery store. Did the property owner have actual notice of the hazard? If the answer to that is yes, they have a duty to warn. It doesn't matter if it's a subcontractor. It doesn't matter if it's an independent contractor. That is what the law says, and that's what got ignored in this case. Because what's being ignored is that there is evidence that this is a pre-existing hazard that was not created by the independent contractor's work. And we've been arguing this from the very, very beginning. And this whole thing gets slipped by. But let's just take everything y'all are saying, assume that what you're saying is true.
All that this fellow was or this who he's working for was an independent contractor.
I'm sorry, Your Honor, I didn't catch the first part of that.
You're saying that it doesn't make any difference that he was an independent contractor.
It does make a difference if the hazardous condition is created by his work. For example, here's the perfect counterexample. A plumber comes into your house. You hire the plumber to fix the plumbing in your wall. You don't know anything about plumbing, okay? He comes in, he starts tearing up your wall, busting your pipes apart. They start leaking and they create a puddle on the floor. You look in to check on his work. You say, oh, there's a puddle on the floor. That's probably not safe. It might be slippery. Well, he's the plumber. I hired him to do his job. I'm not going to tell him how to do his job. The plumber slips in that puddle and falls, okay? You as the property owner, what this independent contractor rule says, you as a property owner, even though you had actual knowledge of that hazardous condition, the puddle, you had no duty to warn him of that because he created that hazard by his work. He did that. In that context, the subcontractor, the property owner has no duty to tell or interfere in how the subcontractor is doing their work. This is a totally different scenario. My client, Mr. Kalos, did not create the unguarded pinch point on this shiv. He wasn't even there to inspect the shivs, okay? So this is no different than if you hire the same plumber, you hire him to come to your house, okay? He comes to your house. Before he can even get and start working on that plumbing, you've got a hidden trap door in your bathroom
Can
right
you
next
respond
to the sink.
how this all fits with Larimore? This is the case where my understanding is the appellate court, not the Supreme Court of South Carolina, said, right, so the subcontractor is injured by a sinkhole, I think, on the property owner's property, and the court says the homeowner did not have an obligation to tell the sub because the homeowner told the general contractor, and it was the general contractor's job to tell the sub.
That was the Lanier case.
Lanier, I'm sorry. Thank you for that.
Yeah, and that's a really interesting case because it doesn't really get into a detailed analysis of why they say that. But the basic takeaway are two things that I could take away from that. One, the court saying, look, the property owner had a duty to warn of that septic tank. Same thing as my hidden trapdoor thing I keep saying. And they did warn of it. They told the contractor, hey, there's a septic tank here. Don't drive over it.
I'm just saying that seems hard to square with your, you always have to tell the sub, it doesn't matter that there's a contractor. That's a case in which you literally, the state court literally said, they told the general contractor there was no further duty to tell the sub.
Well, they told him there was no duty, one, because he had discharged his duty by warning the contractor. And in this case, the evidence is clear. I mean, there is no evidence that Carowinds ever told Dynamic Attractions, the contractor, about this pinch point and this shift. And my time's out, but if I could...
Isn't it true that Dynamic Attractions had been to Carowinds before? They'd had other contracts. They'd inspected this ride before. I mean, this was not the first rodeo for them.
Sure, but that doesn't absolve the property owner's duty to warn. There's no case law that says you have a duty to warn of when you have actual notice of a hazardous condition on your property unless the person is an independent contractor. There's no law in any case that says that, especially not in South Carolina. And in fact, under this Wilson versus Duke case, what the law says is if you have a sub on your property and he gets hurt by a pre-existing hazardous condition that wasn't created by the sub's work, then you do have a duty to warn him if you have actual notice of the hazardous condition, which is exactly what happened in this case. And Your Honors, I'm sorry, I went way over there, so thank you for letting me finish that thought.
Thank you very much, and you've saved some time, rebuttal time, Mr. Parker. Mr. Savon, Ms. Savon, I'm sorry.
That's all right. Thank you, Your Honor. May it please the court, I am Amy Savon, and I am counsel for defendant Appalese Cedar Fair Southwest, Inc., doing business as Carowinds, along with the individual defendants Craig Kennington and Tim Benz. As this court has heard, and as we have already discussed, this is a hired independent subcontractor inspector trained by his employer who has brought this negligence claim against the landowner when he was injured by an open and obvious hazard that was related to his inspection when he did work outside the scope of the contract. Plaintiff was to conduct a visual inspection of the wire cables of this amusement park ride, but unbeknownst to the landowner, his intention the entire time was to conduct a tactile inspection where he was going to hold
Opposing counsel appears to argue that that under South Carolina law, there's a non-delegable duty to warn, regardless of what the contract said, regardless of the prior history of the subcontractor, regardless of whether or not they hold themselves out to be experts in doing this particular act. So how do you respond to that?
I disagree with that, Your Honor. I think you have to look at the relationship both of the independent contractor situation and how an independent contractor is, by definition, there and able to use the manner and methods of which, of their choosing to conduct the inspection, and they control the details of the inspection. That has to be interplayed with what duties a landowner owes an invitee. And it is true a subcontractor is an invitee, but with the subcontractor often has superior knowledge or is thought to have superior knowledge about what it is that they are actually there to do. A landowner has a duty to make the invitee aware of dangerous conditions on the property that exist or where they failed to remedy something.
So what would you say, counsel, what would you say is your best South Carolina case that is most analogous to what we have here?
Yes, Your Honor. And if I can just real quick just say the next part of that sentence is the really important part of which, because it's where somebody has to be reasonably unaware. And Wilson versus Duke Power says that. And Wilson versus Duke Power is a 1979 case, and the Court of Appeals of South Carolina has dealt a lot more recently with cases regarding subcontractors and landowners, and oftentimes affirmed the grant of summary judgment. And I do think one of the strongest cases in our favor is the one Judge Heitens referred to, the Lanier versus Bailey case. That is really strong in our favor because that recognizes the duty the landowner has to the person that it actually hired and the person it has contracted with. And here Carowinds contracted with Dynamic Attractions, and then Dynamic Attractions actually contracted with TechnoServe, who was KLOS's employer. And there is evidence in the record that both the witness for Carowinds, Mr. Hutchinson and Mr. Hopkins, both indicated that the details of how the wind seeker inspection was going to take place and recognizing the dangers that existed with them, that was in the record and part of what was brought up at summary judgment to say we did have conversations with the person we hired and that we had invited onto our property, and that should relieve Carowinds of its duty because the landowner can't necessarily go out until every inspector or contractor that's there on site. Lanier makes clear that it then becomes the responsibility of that contractor to pass on any dangers.
So can I ask you the biggest concern I have with this is, like, I would be totally with you if your client talked to the contractor and then unbeknownst to them, the contractor handed it off to a subcontractor, and unbeknownst to them, the subcontractor sent a guy who wasn't very experienced, and he just goes on the property and gets injured. But a critical factual difference here seems to be that when that guy, that untrained, unsupervised guy, shows up, he was met by two of your company's employees who were told that he was there on behalf of the, you know what I'm saying? It's not like the employees and agents of your company were ignorant that there was a subcontractor, that the subcontractor had spent this gentleman. In fact, they were the last people that he talked to sort of as this inspection is going on and in the moments before his injury occurred. So that seems kind of different than a situation of like, I told the contractor and I assumed the contractor would tell the sub, and I guess I just assumed that they did. It seems like here there's at least evidence that a jury could find that your client knew that wasn't true. Why doesn't that matter?
So the interaction that they had was brief. They did interact with Mr. Kalos as far as actually speaking to him. The difference is that Carowinds does not have a duty to train subcontractors. It doesn't have a duty to train independent contractors. And so this person who was supposed to come onto the site as an expert and was supposed to be trained and was supposed to have superior knowledge, was supposed to be the one who knew what to do, and then on the other hand had the freedom as the independent contractor to then do the inspection as he wanted. It was in his realm to make those determinations. That's where the independent contractor aspect plays into it as well, Your Honor. And so
Well, what would happen, let's change the facts a little bit and just assume there's no contract for a visual inspection. There's no prior history of Dynamic Attractions having done the inspections. There's no representations from Dynamic Attractions as to what their capabilities are. Carowinds just hires ABC Company. It's an oral contract, and the sole terms of that oral contract are come and inspect this particular ride. So how would that change things here, or would it?
I don't think it changed it very much. It makes it, it takes it a little bit out of the contractual context where you can see what each party was supposed to do. But here, and again, I'm not, in your hypothetical, I'm not sure if we've brought this person in directly as our contractor or if it's a sub of a sub, Your Honor, but they're still being brought in as the expert. They're still supposed to have superior knowledge. They're still the one controlling it.
Have they been brought in the hypothetical? I mean, that's debatable. I mean, if the oral contract simply says, we're hiring you to do this inspection, and there aren't any parameters as to what the inspection is to entail or how it's to be done, they've just hired Joe Smith to come in and do that, putting aside whether or not that makes sense or not. But it seems like to me the duty could change in that circumstance from what we have here. I
mean, the duty question does, and the landowner's duty, it does rely on the circumstances. That is true, and that is in South Carolina case law, where you look at the circumstance of what is being brought in. So potentially it could, but it's still, unless Carowinds was supposed to train this inspector, and that was part of what the relationship was, if they're still the person that's brought in to do this annual inspection, that was a requirement that had to be done. They had done it multiple times with the actual contractor that they had brought in to do that with here, then that, I think your example, depending on a little more facts, could weigh into whether or not that creates an issue on the duty.
Can I go back to what I regard as, in many ways, the first really questionable move the district court made, which is just buying this idea that, quote, everyone knows a visual inspection means you're not going to touch the rope. So let's say that I have an item that I'm trying to figure out if it's genuine or not. Say it's a diamond or a gold coin or something, and I bring it into an expert, and the expert says, well, there's more things we could do later, but the first thing we're going to do is conduct a visual inspection. Does it strike you as at all obvious that that expert's not going to touch the item when conducting a visual inspection?
Well, and touching an item like a diamond is different than touching moving wire ropes. Maybe,
but I guess what I'm saying is it's just not at all obvious to me that the words visual inspection mean that no one's going to touch something. It seems equally, if not more plausible to me, that visual inspection is a visual, like using the tactile senses, including the eyes and maybe the hands, in distinction from a scanning electron microscope, or we're going to do an incredibly sophisticated engineering test, or we're going to hit this thing with LiDAR or something, that visual is just shorthand for using the human senses as opposed to some sense-enhancing technology. And in that case, it doesn't seem at all obvious to me that saying he's going to conduct a visual inspection of the rope means, as a matter of law, everybody thought he wasn't going to touch the rope.
And I think that's where touching the moving wire ropes as they're going into a pulley system.
Whoa. I understand the district court's, I mean, that may go to assumption of risk, that may go to contributory fault, because I guess I would say if this case moves any further, I would imagine your client will have a pretty strong argument of how in the world could someone not realize that touching a moving rope is incredibly dangerous. So, like, fair point, but that is not duty. That's assumption of risk. That's contributory fault. But I think I understand the linchpin of the district court's no duty holding to be it is clearly obvious as a matter of law that this contract did not entail him touching the rope. And it just doesn't at all seem obvious to me from the words visual inspection as a matter of law that it was everybody, quote, understood he was not going to touch this rope.
And that's where I think, because it's summary judgment, you look at what all the evidence was, and all
Right.
the evidence from the various people who were deposed on behalf of Kirwan said, no, when we have people come in to do a visual inspection of the wire rope, I do not think that they're touching the wire rope.
But it's not what the individual employees of the defendant claim after a horrible thing happened, what they subjectively expected. The question is what a reasonable person could have expected ex ante.
Right, and that's where, again, I think you have to look at what it is the person's coming there to inspect. And when they hired people to come do the visual annual inspection, their testimony was that they didn't anticipate it would be touched. And you do look at what the
but it's not, again, I guess, like, even assuming for the sake of argument that we believe them, that was their subjective belief. I don't know how you can grant summary judgment on this theory unless you conclude that as a matter of law, no reasonable juror could conclude that that was not an objectively reasonable belief, even if it's subjectively true.
And that's where you look at the plain meaning of the contract, and to the district court judge, and I think to, as argued, that there was no other interpretation argued and put
Sure, there's one I just gave you.
Plaintiff.
The one I just gave you is he's not going to bring any special equipment. He's not going to do a chemical test. He's not going to hit it with a microscope. He's just going to conduct that's the alternative that I'm proffering for you. Why is that objectively unreasonable for summary judgment purposes?
I think because you have to look at the amusement park ride context, and in that context. But what I was saying, Your Honors, plaintiff did not put forward that contention at summary judgment before the court for the court to consider that. And so you're left with the plain language of what does visual inspection mean. I do want to stress that there are multiple reasons why summary judgment was proper, not just the visual inspection contract language, but it goes to the open and obvious, and there not being a latent hazard of which defendants needed to make this independent contractor inspector aware, because it's clear from his deposition that he understood how a pulley system worked. He understood that the ropes were going to be moving, and as your honors asked in opposing counsel's presentation, the fact that they were going through a sheave was right there. It's in the pictures that we put in our brief on page 7. His proximity to the sheave, the fact that the ropes were going into the sheave, that's all right there in front of you, and it's part of a functioning pulley system. And so there wasn't anything to warn. The obviousness was right there in front of you. And a quote from the Delia versus Phillips Edison case, which is not a South Carolina case, but it's a case that opposing counsel cited to you, said, when the claim involves a static condition, if nothing obstructs the invitee's ability to see the static condition, the proprietor may safely assume that the invitee will see it and will realize any associated risk. And that would include this pinch point of the sheave, because it wasn't hidden. That's part of the pulley system, in a way a pulley system works, on this very large machine that in effect was, made up of a pulley system. And so there wasn't anything to make plaintiff aware. There, at the summary judgment stage, there was also no showing that the speed of the wire ropes in any way was improper, and that would have been on plaintiff to put forward an analysis of how the rope was improperly running. There was nothing showing that it was anything different than what had been run on these annual inspections in prior times, or that that he asked any more than once for it to be slowed down. And so,
Can I ask you about the speed? Because you assert in your brief, I think at page 12 and at page 49, that it literally can't go slower than 10%. I'm just having a hard time squaring that with the fact that when the plaintiff asked your client's employees to slow it down, they said they agreed to do it, which is a little bit hard to square with your claim on appeal that it's literally impossible to slow it down.
I think the two employees, I think, testified different. One said it wasn't at 10%, and that was the slowest. And if they had asked for it to been run any slower, that he would have said that's the slowest it goes. I think the other one did say we tried to slow it down or something to that effect. It was a little unclear in that other employee's testimony, but the only clear response was that it was run at 10%. But even if it...
There's also clear testimony that the plaintiff said, could you please slow it down, at least once. And there is testimony that one of your client's employees, quote, agreed to do it, right?
That's correct, Your Honor. There is that in the testimony. There is that. But the issue with the speed is, again, the actual speed it was running was something visible to him. It's not where he couldn't see how fast it was running. He could see how fast it was running and decide whether he wanted to touch it or if he wanted to cancel the inspection and say, I'm not quite sure how I'm supposed to do this because I was touching it. That speed, and if it did get slowed down once, that speed did, he would have observed that. That was an observable condition that he if that was the hazard, which that and the actual potential of a defect on the wire rope were the only contentions of negligence the plaintiff put forward at the summary judgment stage. But that also was something known and observable, and so not anything that we had a duty to warn about. The issue again is, what was our duty? What did we need to do? I want to make a distinction briefly on the Wilson case that opposing counsel brought up. Not only has the Wilson case been kind of analyzed more thoroughly by Lanier, Larimore, Sides, and Peterson, and many of these dealing with the independent contractor situation, but in Wilson, there the landowner had specifically been told by Duke Power that this is dangerous, we're not going to let you build here. And the landowner had decided to build anyway, and that landowner had not made its general contractor aware that Duke Power had basically said, no, you're not supposed to build here. He had not made that general contractor aware. And so it's not the same position that we have here or that happened in the Lanier case, because there the landowner had specifically decided to do something even though it had been told not to. That's different where here we just have an amusement park ride that, in and of itself is large, it's high above up in the air, and has, this pulley system that's there visible and all that it encounters. The proximate cause issue again goes to us not knowing that this person was going to be untrained when we hired someone that was supposed to come in with superior knowledge, and we had actually hired a person we had used, or a company we had used various times to come in, and so that this independent contractor was going to come in and touch the ropes even though the contract called for a visual inspection. All of that together is not something that was foreseeable to defendants, and thereby not only was there not a breach of any duty, but there was not any proximate cause as to anything that the defendants would have been able to do in this situation. For all these reasons, we would ask that the court affirm the district's court grant of summary judgment in this matter. Thank you.
Thank you very much, Ms. Savon. Mr. Parker, you saved some time.
Thank you, Your Honor. I'm gonna, all the swords that y'all have been poking me with, I'm gonna lean into those a little bit. And let's say that everything y'all have been arguing about, you're right. The independent contractor is the expert. They are here to perform this task, and the manner of Mr. Kalos's work is how he got injured. And okay, and that's what I heard from all of y'all. And let's just say that's all true. This was all our alternative argument about why there is a duty to do something, a duty of reasonable care that Carowinds had, and the record shows they did nothing. All those arguments y'all are making, there is an exception to those arguments. And we argued this in our very first brief. We cited to restatement, second of tort, section 414, and it's called the active participation doctrine. And what that says is, if everything y'all say is true and this property owner has invited this sub, a plumber, electrician, whoever, to come onto their property and do skilled work, if the property owner interferes with the operative details of how that independent contractor does their job, now you have created a duty to use reasonable care in those ways that you've interfered with the process. And so this is twofold for us, how we've argued this. And the evidence is again, undisputed in this case. Mr. Kalos wasn't totally in control of how this inspection was carried out. The employees of Carowinds had total control over the speed of those wire ropes. Mr. Kalos's testimony...
Well, hold on. I've seen this diagram. Did anyone tell him he had to stand that close to the pulley? Because when I look at the diagram, I see a place you could stand that's farther away from the pulley, and it doesn't sound to me like anyone told him he had to stand where he stood.
We're just talking about the speed of the wire ropes.
Okay, but you just said they were in total control, and I'm just not sure
of the speed of the wire ropes.
Okay.
I'm totally just talking about speed of the wire ropes right now. They were in control of that. They were down. The testimony is not disputed. They were down in the operation booth. They had their hands on it, had it on. He asked for it to be slowed down. Now his testimony is they did not slow it down. He asked repeatedly, and I'll correct something. The testimony doesn't just say they didn't slow it down. The testimony from Carowinds employees was that 10% was not the slowest speed. The testimony from Dan Hutchinson, who is the owner of Dynamic Track.
Is there any evidence that speed was a causing factor here?
And there is, Your Honor, and the evidence is Mr. Kalos's testimony himself. The district court said, well, it kind of said, where is the evidence of what the reasonable speed was? We don't know that. We don't know what the safe speed is. Well, the testimony is Mr. Kalos's testimony. He's the one who has firsthand knowledge of how this accident happened. He's the person who's been trained to do the wire inspection. He's up there on this platform.
Other than saying he asked them to slow it down, I mean, where's the evidence that you need speed of X, and if it's not X, then that's particularly dangerous, or that's a causative factor? I'm not recalling anything other than Mr. Kalos saying, well, I asked them to slow it down.
Well, you'd have to look at, and we cite this in our brief, it's page 999 of the record. It's Mr. Kalos's testimony. This does not take expert testimony or a knowledge of what the proper speed is. He says, I was inspecting it. I asked them to slow it down. They wouldn't. It grabbed my hand and yanked it into the shiv before I could pull my hand out of the glove. Now, what we are saying, if I can just finish this, is that a reasonable jury could look at that and say, I don't have to know what the safe speed is. If the guy who's doing the inspection tells me it's going so fast that by the time his hand gets caught, he does not have time to pull his hand free of the glove, whatever the safe speed is, this is exceeding it. And he asked them to slow it down. They interfered with how he was doing it. He was actually
where have you made that argument before now?
We've made this from the get-go. That not slowing down the speed of the wire rope, approximately but for cause and proximate cause of his injury, because he couldn't get his hand out of there. It got yanked into the shiv before he had time to react to that. I mean, we've, in the proximate cause section of our brief and this appeal, we've put it out there pretty clearly. And there's two, it's page 614, page 999, it's in the record. That he, the eyewitness to how this accident is happening, it was going too fast for me to protect myself, for me to get my hand out of there. We don't need to know what the safe speed is. All the jury needs to infer is it reasonable to infer that that was unreasonable for them to be operating that fast? Especially when he's saying over and over, please slow it down. They're not slowing it down, and they can slow it down to a speed that's 33%, according to some of the testimony of how fast they were operating it. One of the employees said the lowest speed was 3%, and they were at 10. So I think there is evidence of the but-for part of proximate cause under South Carolina law. There is evidence that this was foreseeable because, I mean, this is, you fail to warn of a pinch point hazard, someone gets their hand stuck in it, that's the definition of foreseeable, of the likely consequence of you failing to warn someone of something. And so there's the speed issue, but then also the control of the platform. And Judge, you're correct. There is no evidence that anyone told him to stand on that first platform, but what there is evidence in the record of is that Carowinds maintained control of where they inspected from. And these are the documents that we cite to as testimony. The diagram is on page 1324. It shows.
Wait, so this is the evidence that you initially cite in a pretty clear violation of Federal Rule of Evidence 407, and then have a fallback position of how it has some permissible uses that don't violate Federal Rule of Evidence 407?
Right, because we're using it to show evidence of control over the sub and not to show evidence of liability.
Well, but okay, so even taking it for that purpose, the fact that they later said you can only stand here, I guess establishes maybe that at the time of this inspection, they could have insisted that he only stand in one place. But I don't think that establishes that they insisted that he stand where he did. I think it's more consistent with the idea of, like, before this accident happened, they left it to the subcontractor to decide where to stand.
Well, I think the bigger question is if they retain the ability to control where he inspected from, which also Mr. Benz, his testimony was, if I would have been up there and seen him standing on that platform, I would have told him to get on the other one, which evinces evidence in the record, summary judgment, some measure of control over not how he's doing the inspection, not how he's looking at that wire rope as it passes by, but where he's doing it from. It evinces some measure of retained control. And then the question isn't, well, you didn't tell him where to stand. The question is, why didn't you tell him the safe place to stand? You had a duty to use reasonable care to exercise that control over how he accessed the tower and where he inspected from, and you did nothing. You told him nothing. It's gross negligence. So I'm well out of time. I appreciate the opportunity to speak to y'all today. Thank you.
Thank you very much, Mr. Parker. With that, this matter will be taken under advisement. And as I've said in previous cases, if we could do so, we agree counsel in the well of the tan courtroom, but we can't do that today. We'll have to do that some other time. With that, unless one of my colleagues needs a break, we'll call the fourth case. And Ms. Osmond is represented by Mr. Corbett. Good to have you with us, Mr. Corbett.
Thank you, Your Honor. I appreciate that. It's good to be back here. I actually had the honor last time of being the first group to shake the hands of the panel after COVID. So I think it's only fitting that I missed the opportunity this time. May it please the court, though, when a district judge is acting as finder of fact, Rule 52 requires them to be specific when they make those findings. So when a party's testimony is found to be not credible in its entirety, we'd expect that heavy, truly dispositive finding to be fully explained. And the only explanation we got from the court below, and essentially finding that my client invented her claim entirely. that she was inappropriately touched by a TSA screener was that she would not admit to remembering a social media post that they surprised her with at trial that she supposedly made over a decade earlier, containing a mundane gripe about TSA. Now, that's obviously too thin of a reason to treat everything else that someone says under oath as a fabrication. That would be clear error. But it begs the question, okay, what did motivate the district judge to make such a finding? And I'd submit that implicit bias, the idea that whether we want to admit it or not, we all prejudge things subconsciously and often unfairly, is so impactful on the legal practice that there are MCLE courses on the topic. And in part, due to social progress in the last decade, I'd like to believe that it's common sentiment in 2026 that it would be unfair to say that someone who has been sexually assaulted in the past is less credible if they allege sexual assault in the future. Implicit bias maybe, but we probably wouldn't say that, except defense counsel did say it in their close, that Mrs. Osmond's prior assault, quote, contributed to plaintiff's erroneous perception of what happened, of what occurred. Her erroneous perception of how she was being touched. So the district judge didn't specifically said he wasn't making a finding as to whether or not that prior experience of the plaintiff contributed to her perception or not. Perhaps because he knows that that would be unfair, or perhaps because he knows that that would also be clear error under FREs 402 and 403. But there's good reason to doubt.
Counsel, what exactly are you arguing is the error here?
The error here is that under Rule 52, the court is required to explain its findings of fact. The court said that my client was not credible because she didn't remember a 12-year-old tweet that she made that she was surprised with in court for the first time, not during a deposition, and because she wouldn't say, I remember making that everything else she said was not true. That she made up the entire claim, she made up the words that she said that this TSA screener said to her while she was being touched, she made up how she was being touched, all because she wouldn't admit to remembering making a post that a reasonable person might not remember making. I certainly don't remember.
Mr. Corbett, you just said something that struck me as wrong, and I just checked. You said the district court not only has to make findings of fact, but the district court has to explain why it makes its findings of fact. And you represented that Rule 52 says that. Where does Rule 52 say that? I'm looking at it. It's 52A1. It says that the district court must state the facts specifically and state its conclusions of law separately. I am not seeing where it says the district court has to say why I decided someone was or wasn't credible. Where does it say that?
And that's a fair point, but the court did decide to say why.
I know, but you said the district court violated Rule 52 by not adequately explaining why it made the factual findings it did, and I'm not sure what the legal support for that is.
Yeah, I mean, so if we're going to interpret Rule 52 to just say you don't have to have any explanation at all, then the judge could, if you take it to the extreme, just say, I find that this party hasn't made out their claim, so they lose.
How about I listen to the evidence, I look them in the eye, and upon observing their testimony, I don't believe them.
Yeah,
which is what juries do all the time in cases. Yeah. And juries don't even have to make findings of fact. Juries can look people dead in the eye and say, I simply don't believe you.
Yeah, and honestly, if the judge had wrote that, I think we'd have a much harder case here.
Let's think about what the Judge Ridinger did write. He wrote a 21-page memorandum of decision and order and said, upon consideration of the testimony and evidence presented, the court hereby enters the following findings of fact and conclusions of law. 21 pages after the bench trial was conducted. And
yeah, I mean, in fairness,
like you're wasting our time talking about this.
Most of those 21 pages were written by defense counsel. Their findings of fact were pretty much adopted in full. But what I'm trying to say is, I'm sorry, I might be cutting out. I don't want to talk over you.
It was written by Judge Ridinger. He signed it on page 21.
Right, but before he wrote this document, he had the parties submit proposed findings of fact, and it's
Oh, and that's
largely.
what courts do time to time. And here you've got a bench trial. Of course, you have no jury trial. This is the Tort Claims Act case. There's no right to a jury trial. The statute calls for a bench trial. And you got a bench trial. And so Judge Ridinger was the fact finder. And he was the judge and jury, as they say. And that's the way this system works, these Tort Claims Act.
Let me narrow, I guess, what I'm trying to say here and make it a little bit easier. If a court decides to say the basis for their fact finding, and that basis is
surprised that you start off your argument by attacking the trial judge. That's the way I take.
Your Honor, I don't mean it as an attack, but I
It simply doesn't, as a plaintiff's lawyer, it doesn't make any sense to me.
I think it cut out, so I'm not sure if I heard your question, but I'm not trying to attack anyone. What I'm trying to say is that we all have our biases, and we all judge things in different ways, and I'm kind of getting into it, but the reason that we can know that there's something more going on here is that the judge explicitly said, I think that she's not credible because she didn't remember that post, and that's just clear error. That's just wrong. You can't discount someone's entire case just because they don't have recollection of something 12 years ago.
It's not hold on. That's not fair to the trial judge, because it's not just because you don't remember it. It's that when confronted with something that for all the world looks like a Twitter post by you, you insist that it's not you, couldn't have been you, wasn't you. I mean, let's just posit that before I was a judge, I had a Twitter account too. That was my first name at my last name. And if someone showed me a post that looked for all the world like a post from my account, and it's not even just that here, right? Because as I recall, the post in question was like on a screenshot that showed a post that unambiguously was by her, right?
Right. So
So I have a screenshot that shows what appears to be my Twitter account, and it shows a post that I 100% wrote, because it's the post in which I complained about the very incident I'm suing about. And then seemingly appended directly on top of that is another post that I made. And it's not just I say I don't remember it. I insist that, notwithstanding the fact that it looks for all the world like it's from my Twitter account, that it definitely wasn't me.
So my client didn't testify it definitely wasn't me. The question was, do you remember making this post? And she said, I don't remember making it. And frankly, any attorney will tell their clients, if you don't remember something, don't let them bully you into saying that you do just because they make it seem like you must remember it. If the question is, did you probably make this post, she would have answered yes. But that wasn't the question. It was, do you recall making it? And the answer was honestly no. If we look at page 53 of the trial transcript, the answer she gave on line 4 is, quote, yeah, I can't recall writing anything. She's talking about these posts. On line 16 of that page, I don't recall that. On 23, I don't recall. And the problem is she kept getting badgered by this attorney who surprised her with this post and keep in mind, she's also a journalist. She's a writer, so she has thousands of social media posts. There's no way she could have possibly remembered every post that she wrote in her entire career. And to make a big deal out of her not remembering, not saying this definitely wasn't me, she didn't say that. She just said, I don't remember writing it.
Can I ask you about a finding the district court made that you don't address that I have? So let's posit for the sake of argument that I think that at minimum the district court used some loose language about mens rea and may well have been wrong about mens rea. But there's this finding the district court makes at JA 431. Quote, the evidence presented at trial conclusively demonstrated that the pat-down of the plaintiff was objectively reasonable and proper. I don't read your brief to argue that that finding is clearly erroneous. And if that finding isn't clearly erroneous, why is that not completely fatal to a battery claim?
Yeah, I mean, I think that's it's kind of implied that finding isn't valid because the findings that it was predicated on were.
No, but I guess what I guess is let's say only for myself and only for the sake of argument that I don't find your attacks on the district judge's credibility findings persuasive, but that I am potentially open to the argument the district court was wrong about the mens rea required for battery. But even if that's true, why wouldn't the finding that I just quoted you mean that any mistake about the legal mens rea requirement doesn't matter because the district court made an alternative factual finding that would be absolutely fatal to a battery claim?
Yeah, that's kind of why I started my argument with the factual finding, because I think that's what needs to be, what can be clarified in oral argument. I think you're right that the error as to the mens rea is pretty apparent from reading the papers, and I don't think I'm going to change your mind on that one way or the other at oral argument. But as to the facts, I can only be here to offer clarifications that weren't there in the documents, such as.
Let me put it just a different way. If we were to conclude the district court did not commit any clear error in its factual findings about what happened in the world, is there any other argument besides that one that any error about the mens rea requirement would be harmless error because of the district court's alternative finding that this was objectively reasonable?
I think that there's some mixing of the arguments. If you think that the person hasn't shown that they were touched inappropriately, then it's easier to kind of combine those two things together. And we see a little bit of blending of facts and legal conclusions in the document. So I guess if we are to conclude that my client was definitely touched in accordance with TSA procedures, then no, the case is over and we don't have anything. But I think one can say, look, this judge was wrong on the law on this, and that may have affected his decision-making on the facts. I think that you might be able to go and take another look at it.
So I'm a little confused with the stream of consciousness here. There is a finding, as Judge Hyten's represented, that the touching was objectively reasonable. And I don't hear you saying that you have challenged that finding other than collaterally because you say the district court judge was so biased that it had to be an erroneous finding because of that.
So the bias comes in where the judge discounted my client's testimony entirely. So my client testified that she was touched in a way that was not in accordance with TSA procedures, that they used the front of their hands to place them directly onto her genital area, which is not a part of the pat down there.
Right,
So
all that's trial evidence. So you have the district court judge saying this was objectively reasonable, and it's your obligation on appeal to say, okay, that's wrong, and here's why it's wrong. So what I'm asking is, where do you do that?
Right. So if the court said to in this thing, look, let's say your client does show that she was touched that way, it's still objectively reasonable, then we would have an improper determination of law. But I think that the issue here is that the district court rejected that my client was touched as we allege she was touched. And that's the core. If she was touched in the way we allege she was touched, there's little dispute that she was touched unreasonably. But because the court found that she was not credible, it found that she wasn't touched that way, and it found that it was reasonable. I see I'm over time. I have time for rebuttal.
So you've saved some time, Mr. Corbett. Mr. Beck?
Yes, Your Honor.
Beck?
Yes, Your Honor.
Mr. Beck, we can only see you from the eyes up. At least that's all I can see.
See if I can adjust this.
All right, that's better.
Okay, sorry. My name is Gil Beck. I am an assistant United States attorney. I'm representing the United States. This case was primarily about findings of facts, credibility determination. The trial judge had the opportunity firsthand to listen to the testimony, to view the evidence, and determine that Officer Robinson was credible and that the plaintiff was not. In addition to the point that has been made with regard to conclusion of law 18 that the TSA following the TSA procedures conclusively demonstrated that the pat down of the plaintiff was objectively reasonable and proper. Another way that the court can find or affirm the district court is based on finding of fact number 55. In finding of fact number 55, the court states the plaintiff failed to prove by preponderance of the evidence that LTSO Robinson placed her hands on the plaintiff's bare thigh, inserted her hand inside the bottom of plaintiff's shorts, or used the front of her fingertips while searching the plaintiff's genital area. It's not necessary to get to the intent, although we're prepared to address the intent issue. The district court's findings is due the highest level of appellate deference, and where there are two competing views of evidence, the fact finder's choice between those two competing areas can almost never be clearly erroneous.
Well, counsel, what I understand opposing counsel to argue, I may be incorrect here, but my understanding was that even if you accept these factual findings, that they're invalid, for lack of a better word, because there's some implicit bias on the part of the district judge. Do you have a response to that?
Yes, Your Honor. First, I don't think there's any basis whatsoever with regard to that. And then second, with regard to the findings of the district court judge, there are many findings that explain the district court judge's findings, his reasoning, and the thought process. For example, the district court judge found that Osmond's testimony was not credible about her statement that Officer Robinson made a comment about the shortness of her shorts. That's at page 423 of the joint appendix. The district court also found that Osmond was not credible when she allegedly said that Officer Robinson said, "If you resist, then I'll do it again," meaning search you again. That's at joint appendix 423. The district court found also that that Osmond was not credible when she testified that Robinson allegedly placed her hands on the plaintiff's bare thigh. That's joint appendix 424. The district court found that Osmond was not credible when she alleged that Robinson inserted her hands inside the bottom of the plaintiff's shorts. Joint appendix 424. The district court found that Osmond was not credible when she testified that Officer Robinson used the front of her fingertips while searching the plaintiff's or performing the pat-down. Joint appendix 424. The record is thorough, complete, with many explanations based on the testimony of the trial court that explain his decision. There is no indication that implicit bias influence the district court's decision, and the district court's decision should be affirmed.
Matt, can I ask you again whether this matters or not, given this finding that there was no objectively offensive touching? Bracket that. I will assume that your response to every single question I'm about to ask would include, "and none of this matters because." Let's posit that I understand the "and none of this matters because." So I first want to make sure if we agree on what the mens rea requirement is. So let's say the evidence shows that the screener in fact touched a certain part of the plaintiff's body, and that the screener in fact intended to touch that part of the plaintiff's body, right? Like, it's not like I went in to reach in an attempt to touch your arm, and then because you moved, I ended up touching not your arm. Like, I touched in place X, and I meant to touch in place X, right? If we establish that, do we agree the mens rea, do you agree the mens rea element is satisfied? As long as we establish the screener meant to touch that particular part of the plaintiff's body?
No, Your Honor. Under North Carolina law, the liability for intentional tort of battery hinges on the defendant's intent to cause a harmful or offensive.
I understand there is some loose language in cases that say that, but there are also cases that break down and say that's not like, this is torts 101. It is not a defense to battery to say, I know I did X and I meant to do X, but I subjectively don't believe that what I did was offensive. That's not a defense in battery.
Yes, Your Honor. But under North Carolina law, there is, in effect, the requirement to do more than just the intent to make contact. So it's not single.
I understand. No, that's why I gave you the example where I did mean to. I understand this example where I mean to touch the plaintiff's arm, and I accidentally touch a significantly more intimate, private part of the plaintiff's body than the arm. But so I agree. It's not just enough that I meant to touch them somewhere, and that I ended up touching them somewhere was offensive. So the hypo I'm giving you is I meant to touch them precisely where I touched them. And what I don't understand is what more is required under, and this is where I think the district court is wrong, because I read the district court as saying the TSA screener didn't mean to be offensive, and I just don't think that's an element of a battery claim.
The intent under North Carolina law, which in the case of Andrews versus Peters applies the restatement second of torts, is the intent to cause the consequences of the act, which is the offensive touching in this particular case. So there is a requirement to touch with the intent of that touch being offensive.
And what case says, you claim that it's Andrews that says that?
Andrews versus Peters, Russ versus Great American Insurance Companies, Britt versus Hayes. This is an area.
You would have to, the defendant would intend, as Judge Heitens puts it, to touch place X. But wouldn't it be an objective test as to whether a reasonable person would find that touching a place X to be offensive? It really wouldn't matter what the defendant's state of mind was, other than that they meant to touch that particular place.
Correct, Your Honor. With regard to defining offensive, that is an objective standard, correct. This is an area.
So I think it'd be fair to say that there's, you could cite some North Carolina cases both ways, but as a general proposition, it's not a subjective, it's not a defendant's subjective mens rea to the effect of the touching, but an objective test.
If I understand the question correctly, the definition of what is offensive is determined by an objective test. The intent of the alleged tortfeasor includes a subjective component of intending to cause a harmful or offensive contact.
So I guess I'm just saying, I'm looking at Andrews now, and I'm looking at the point where they block quote Prosser and Keaton on torts, which is, pretty close to the gold standard of what the common law of torts is. And this is the block quote that goes from 640 to 641, and it says, the intent with which tort liability is concerned is not necessarily a hostile intent or an intent to do harm. Rather, it is intent to bring about a result which will invade the interests of another in a way the law forbids. Not that I intend to invade their interests in a way the law forbids. It will do that, right? And then, this is the part that seems really important to me. The defendant may be liable, although intending nothing more than a good-natured practical joke, or honestly believing that the act would not injure the plaintiff, or even seeking the plaintiff's own good. None of those are a defense to a battery claim, right? If I do something that is, if I intentionally do something that is in fact non-consented to and offensive, it doesn't matter that I didn't think it was offensive, right?
Your Honor, I believe the Andrews versus Peters case provides...
I'm literally quoting from Andrews versus Peters right now.
So if we look at the facts in that case, the defendant said, I didn't mean to hurt this person. What the defendant did was come up behind a coworker and basically place his knee into the back of the knee of the plaintiff, causing her to fall, break her kneecap, have very severe injuries. The defendant's defense was slightly different than the way you are articulating. The defendant's defense was, I was playing around, I didn't mean to cause harm, I tried to catch her, but he had the intent to commit an offensive contact. That is the key with regard to Andrews versus Peters.
He intended, no, sorry, I don't understand why you're fighting me on this, because I'm literally looking at Andrews right now on page 641, where the court literally says he does not deny that he intended to tap her knee. And the court says he doesn't deny that he intended to tap her knee, and it says tapping her knee is offensive as a matter of North Carolina tort law. And what the Supreme Court of North Carolina says, once I know he intended to tap her knee and that tapping her knee is in fact offensive, donezo. Nothing else about what he intended or wanted makes any difference whatsoever at that point.
The difference, I believe, is if you look at Andrews versus Peters, where it says...
I'm reading Andrews versus Peters.
Yes, sir. I mean, I recognize that. Liability for the intentional tort of battery hinges on the defendant's...
I know, there is one broad sentence that you keep quoting, but then I am reading the part where the court explains the outcome of that decision, and their explanation for their decision is he meant to touch her knee, he did touching her knee, touching someone's knee without consent is offensive, ergo, that's a battery.
And counsel,
the actual holding of that case is.
You realize that you could concede this point, but you could still prevail.
Yes, Your Honor, and, but I believe it's an important point, and I recognize the points that are being made, but I believe it is an important point because North Carolina has preserved in its common law the common law requirement of a subjective intent to cause harmful or offensive conduct.
If this issue were dispositive, and if we were in any other state but North Carolina, we could certify the question. But I would represent to you that this is not dispositive, and that regardless of what we decided, if we were deciding this particular point, no state North Carolina court would be required to give it any deference.
Yes, Your Honor. I recognize that, and I totally agree that the case can be affirmed on the failure of the plaintiff to prove the offensive or harmful contact. I don't mean to belabor the point with regard to intent. If the court has no further questions, that concludes...
Oh, I have a couple. How in the world does the federal government as a defendant misspell the name of its own employee and assert that you don't know where they live?
First of all, I will take responsibility, and I could have done better, but I went on the information that I received when I made the initial disclosures, and I provided all of that information to the plaintiff. When I made this first supplemental, I did the same. All the information I had, I provided to the plaintiff. And when I made a second supplemental disclosure, the same thing. So I provided all the information that I had. The district court found that that was an adequate...
Were you representing that someone else gave you information that misspelled an employee of the federal government's name?
Your Honor, in retrospect, I agree completely that I could have done better. I was not aware of that. I provided all the information I have, but I recognize your point, and I wish I had done better.
All right, let me ask another question then. I don't understand, as a matter of federal rule of evidence 404, how the fact that there had been complaints against this person in the past isn't improper character evidence that's barred by Rule 404?
First of all, there was no objection to that testimony. To the extent there was no objection.
What material fact is made more or less likely by the fact that this person hadn't had previous complaints, except the inference that because there hadn't been complaints in the past, she must not have been bad in the past, and because she was not bad in the past, she must not have been bad here, which is literally the very inference that 404 says you can't draw.
With regard to that, it was part of the overall description of this particular TSA screener was very conscientious, was very dedicated, was very professional, and it was part of that composite picture. If the objection had been made, then the court...
Doesn't that all presuppose that the fact that she was conscientious and careful and didn't subjectively want to hurt the plaintiff is legally relevant in the first place?
Correct, Your Honor.
But if it's not, all that testimony becomes improper too, right?
I would comment that since this was a bench trial, most judges that I've dealt with trying bench trials don't pay much attention to the rules of evidence. They want to hear whatever they can hear, and they can figure out what to consider and what weight to put on it. Anyway, the rules of evidence are not enforced in bench trials like they are in jury trials.
And certainly, the trial judge knew what weight to put on that evidence. Even taking aside all of that, there was ample evidence to support the district court judge's decision. And if there are no further questions, that will conclude my remarks. Thank you. We would ask that the court affirm the district court. Thank you.
Thank you, Mr. Beck. Mr. Corbett, you've got some rebuttal time.
Thank you, Your Honor. I want to start by clarifying that my point is not that even if all the judge's conclusions of fact are correct, that it should still be overturned by some kind of tangential bias. The idea is that these determinations of fact are inaccurate because of prejudging. And part of it is, if I can move on to the evidence, which seems to interest the court a little bit more, part of it is that the evidence that came into it was oftentimes things that should not have come in. And I think that the court should, it would be wonderful if the court could recognize that the adage that a judge in a bench trial can hear everything and just exclude everything that isn't relevant like a robot, and everything is no harm, no foul, I think should start to be rejected. I don't think that one can say it's no harm, no foul to take in all of this evidence, to take in evidence of how an allegation made the defendant feel, to take in evidence from another TSA screener who testified how 9/11 made him proud to be a TSA employee over objection. All of this evidence came in to make it seem as if this group of people was professional and on it and doing their best, and all of these things were not necessarily relevant. And that is going to color a judge's perspective, even if they say it won't. And to tie this back to where I started this, when a judge says, I determine that someone isn't credible, and then gives a reason, if that reason was because witnesses who testify on Tuesdays aren't believable, the court would obviously say, well, that's clear error. And I'm asking the court to go a little bit further than that, obviously, but to say, look, a person saying, I don't recall a Twitter post from 12 years ago, if that is truly the basis for your decision that they're not credible, then you've made clear error. So I'm not trying to speak of bias in the abstract, and I'm certainly not trying to attack the district judge at all. But all of this came into this court, and we expect judges to separate it out, and it just doesn't work like that in the end. In the end, we don't know why the court made some of these determinations, and some of them were, in my view, clearly wrong. For example, others were countered by evidence on video. There's video evidence in there that clearly shows that this screener is using the front of her hands to pat down the genital area of my client. And the court adopted the proposed finding of fact of the defendant that the hands were probably just floating there, not actually touching. Now that's, to me, that's turning a blind eye, because it's finding a way to explain what you've already concluded, rather than trying to use the facts that are in front of you to make a conclusion. So in the absence of some kind of reason to think that my client wasn't credible, and I watched her eyes and thought she was lying, would be a much better reason than she didn't remember a Twitter post, to Your Honor's point. But that wasn't the one that we were given. We were given all of these other reasons, and in the findings of fact, we were given probably half a dozen findings of fact that the court later said, I'm not taking this into consideration. And the question I would have is, why would a court find something as a fact if it's then going to say that's irrelevant? I think in this context, where the judge says that the testimony was not credible for a reason that's just strange credulity, and then says all these other facts, by the way, were true, but I didn't take them into account, I think the court really needs to analyze a little bit deeper into what actually led for this. And look, I realize I'm making an uphill battle. I understand that asking for a reversal of a judge's determination of credibility is the highest of hills that I could come here on an appeal for. But in light of all of this bad evidence that came in and the reason given, I think there's some reason for the court to actually take a little bit further of a look and see if it actually makes sense. If no further questions, I'll yield my time.
Thank you, Mr. Corbett.
Thank you, Your Honor.
That we will take this appeal under advisement, and that being the final appeal of the day, Madam Clerk, we will adjourn court for the day.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.
Thank the council very, very much for their work. We appreciate it.